Monday morning to ya. Hey guys, I hope you guys had a great weekend. I have got 50 million things popped up all over my computer right now this morning. Hello everyone. Good morning. Good morning. Make sure my mic's on. Y'all always got me so worried that my microphone isn't working or something stupid. Good morning, good morning. Hey, Kel. Good morning, Michelle. I was reading your comment. That is great news. Yay! I'm glad. I'm glad. Unpacking at her new place, though, that's kind of refreshing, you know? So relieved. Got to take her shopping so she can get new clothes to look nice there. Aw, cute. So cute. Hey, Morgana. Good morning, Kel. Good morning. Good morning. Michelle tosses Pepsi into the chat. Good morning. Good morning, Sherry. Good morning. Good morning. Morgana says, thanks you guys. Thanks you all. I'm feeling pretty good. Good. She's picking out how to decorate. Aw. I love that. Good morning, Sherry. 2 Sherrys. Got 2 Sherrys in the chat today. 2 Sherrys. Oh, this is a new coffee. It's not new. It's just, it's, here, I gotta turn it around so you can see it. I don't want to spill my coffee. Isn't that cute? It's so cute. And I don't even like cats, but it's cute. I don't really have anything against cats. I'm allergic to them. That's really the only reason I don't like them. But yeah, I've got a pink one and a white one. They came from the Dollar General, y'all. I've had them forever. And ever. And ever. All right. So, here's the thing. Since I missed Friday. Oh, and by the way, Friday's appointment went great. So, yeah, Friday's appointment for kiddo was fine. Everything was good. Good. But because I missed, I did not stream day 5 of the corn rake murder trial. Okay. So, I mean, I guess I can ask you guys what you want to do. Did anybody watch it that day? Or were you waiting on us to watch together? I know that his attorney was back on the stand. Well, not on the stand. I think it was via Zoom. But do you guys want to go ahead and start back at day 5 since we missed Friday? What say you? Thanks, guys. Yeah, I appreciate it. Kel didn't watch day 5. I watched part of it, but not I kept falling asleep watching. I'd start it and then I'd fall asleep. And then I'd start it again and then I'd fall asleep. And then I'd start it again and then I'd fall asleep again. So okay, Sherry didn't watch it. The other Sherry didn't watch it. Kel didn't watch it. Michelle watched bits and pieces, but she's fine to watch again. Okay. Well, then let's go ahead and just start back at day 5, and we'll be a day behind. So. Morgana says, I'm not invested either way, so whatever everybody else wants to do is fine. Okay. Then we'll go ahead and start back at day 5. I got my banner up. Oh, where did it go? Which way did I go? Which way did I go? Exit out of that. Bum ba dum bum bum bum. It looks like there's another trial. Colorado v. Stacy Rodriguez. House fire homicide. Oof. Who died? Oof. 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 Anybody been checking that one out? And then I saw that the Jermaine Bass, the one that killed his kids, um, sorry, I'm just scrolling through here looking and seeing things that I've missed. Um, I missed the Menendez brothers family press conference too. Dang it. That's what happens when you miss a day of the interwebs, right? And then there were the Oscars. I didn't watch the Oscars either. I didn't do any of the things. Sorry. Da, 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 da. Morgana says Karen Reed could get explosive this week. Ooh, do tell. Do tell, do tell, do tell. Um, Michelle said it lets us jump ahead during breaks and lunches too. Zoom. Zoom, 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 and a boom, boom. Just shake your rump. Not too busy. No, too busy this weekend to do anything but catch my breath. Yeah. I'm still in the loads and loads and loads of nothingness on the weekends, but a lot of sleep. Um, I feel like a smish better as far as like hormones, like my thyroid stuff, I think, but uh, far away from 100%. I'll tell you that. You want to see what? Oh, the Menendez brothers. Ooh, they're having court 3 days this week in Karen Reed. Good morning, Donnie. Good morning. Take every little bit of better you get. Take every little bit of better you get. Hey, C. Morales. Good morning. Good morning. Good morning. Oh, and side note, you guys, too, we're going to have just a little bit of chitter chat since, I got to catch you all up. So, you guys know that I had switched from. Oh, I get you. From the thyroid. Take every little bit of better you can get. I got you. I got you. Yeah. Like, soak it up, soak it up, soak it up, right? Every little bit of better. Um, you guys know that I had switched from caffeine to decaf. It's sad water, sad coffee bean water, I know. But I had switched because I had found out that caffeine was causing my massive spikes in blood pressure, like massive, major spikes. I'm blaming that on my thyroid too because, your thyroid can determine how your body reacts to caffeine. I didn't know that either. until very recently. I think QB mentioned that to me, and I was reading about it too. But anyway, I switched to decaf. Well, there was one little coffee pod in the bottom of my little canister that I keep my little coffee cup K cups in. That's a little cute glass jar container with a little black lid, that sits next to my thing, coffee maker. And I pulled it out, popped it in, made a cup of coffee. And then lo and behold, realized later that that was one of the regular coffee K cups that was left in the canister that was not decaf. I hadn't had caffeine in several days, right? And I'm telling you, no, I wasn't wired, Michelle. No, I got weak as a kitten. My arms felt heavy. I was having cold sweats. I couldn't move. I felt like I was having a complete blood sugar drop, or I don't know. My blood pressure did spike up for a little bit, but then it came back down pretty quick. It was weird. I was like, oh my God, I think I'm going to die from a cup of coffee. I'm like, and I drink 3 or 4 of those a day normally, but yeah, no. So, yeah, I drank a lot of water to try to flush it out. And I made my husband, I told Dale, I'm like, I don't know if I need protein or sugar. Go get me a piece of cheese and something sweet. And I laid there in my chair with my fan on my face. I was just like, and it finally, I did nap, slept it off. But oh my God, it was horrible. And I was like, I don't want to make that mistake again. That was awful. Awful. Maybe I need to switch. Just trying to switch from Pepsi to unsweetened tea first. Yeah. I don't know. All right. So we're gonna get to it. But yeah, the coffee situation I'm sad about because I like my regular coffee. I mean, decaf tastes okay. It's not that it tastes bad. And I know that even decaffeinated coffee still has a very tiny bit of caffeine in it. They can't get it all out, but they, whatever the process is to get the caffeine out of it, I know they can't get every little bit of it out. So, just in case you did not know, if you drink decaf coffee, there's still going to be a smidgy smush of caffeine in it, but not nearly the amount. So, anyway, just so you know. Morgana says that's a travesty, Michelle. She says, Morgana, I know, but the Weight Watcher points. Yeah, I know. It's a lot. It's a lot. All right, let me share my screen with you. I say that, but we bought 3 cases of Pepsi yesterday. Well, there you go. Uh-oh. I always get into these headlines on the homepage of my computer. It says fast food chain announces major change to legendary burger on the menu since the 1970s. And it looks like a Whopper. So I don't know. It didn't say which restaurant. But I always get a hoot going through these headlines. Okay. All right, I got to get out of it before I go down rabbit holes, man. Rabbit holes. Okay, let me X out of this tab and this tab. And give me just a couple more seconds. All right. Gave up fast food when you had your gallbladder removed. Mm. We don't eat at restaurants or fast food restaurants very often at all anymore. I mean, we go in through spurts where we will for a little bit and then we won't for a long time. And we haven't for a very long time. Now, we did stop at Arby's on Friday on our way back from the doctor's appointment because we promised the kids chocolate milkshakes. So we stopped and got them chocolate milkshakes at Arby's. And I saw the sign that said potato cakes are back forever. And I know, Morgana and QB talk about potato cakes all the time. And I'm like, get me some daggone potato cakes. So I ate some potato cakes. They were so good. It was like super hot and fresh and crispy, like burn your mouth up hot and fresh. So I had to break them in half and let them sit and cool off for a minute. That was torturous. But oh my God, they were so good. Um, but that was all I got was the potato cakes and the kids' chocolate shakes. And mm, yeah. Okay, now I can present the screen. There we go. Make it big, large, and in charge. I have not tried the Thin Mint Frosty yet. I have not. Sounds good though. Yes, C. Morales, fast food gets expensive. Remember when everybody used to have the dollar menu? Remember, you could we used to do that a long time ago. We would go and get like a bag of cheeseburgers from the dollar store. No, not the dollar store. From McDonald's, and have like cheeseburgers for like, yeah. I'm sorry, C. Morales. We do that randomly here. It is the Crime Cafe. Cafe being food, coffee, chitter chat. Mm. Mm-hmm. Kids meal for $2, right? A happy meal. Yeah, this is the cafe portion. All right, we will get started though, because I'm going to talk myself right into going in there and getting me something to eat too if I ain't careful. All right. So the first person that we have on the stand is this dude here, who is the Mullis family farm insurance dude. I do not understand why he's even on the stand. I can't make heads or tails out of what his testimony is supposed to prove or disprove. I'm really confused because they talk a lot about Todd using the planter, tractor, machinery, whatever, to plant on the farm and his family's farms. But I don't understand what any of that has anything to do with him allegedly killing his wife. I don't understand it. So if anybody can hear this testimony and tell me what the point of it is, I would love to know. Yeah, that's true, C. Morales. You can't buy anything for $1 anymore. Not even at the Dollar Tree. Go figure. All right, I'm going to start this, and here we go. Let me skip till they introduce their first witness. Like I said, y'all gonna have to make heads or tails out of this witness and tell me why he's even on the stand, what his purpose in being there is. Because I have no clue.
We'll go ahead and go on the record. Are there any preliminary matters that we need to address this morning? Anything on behalf of the applicant?
Just on the applicant's end, Your Honor, we, want to keep things moving this morning, and we can confer further with scheduling about with the court about scheduling, maybe at a break. But we do have our next witness to proceed, and I think we've conferred with the state about that. So,
okay. Any preliminary matters on behalf of the state?
No preliminary matters, I think, other than the scheduling matters that we have before the court here today, as well as the potential ongoing discussions for stipulations.
Who, Michelle,
Right.
the
Wonderful. You may call your
insurance
first
person?
witness.
It's a man.
Good morning, Your Honor. The applicant calls Mr. Blake Heeman.
Okay, Mr. Heeman. See you outside. All right,
He's
great.
cute, too. He's cute. There he is.
Good morning, sir.
He's handsome.
Come forward, please, and have a seat in the chair to my left. If you'd raise your right hand. Do you swear the testimony you're about to give will be true and correct?
I do.
Okay. The microphone is on. Just adjust that as you need to so you can sit comfortably. Ms. Neshwa, whenever you're ready.
Good morning.
My name is Dina Neshwat. I'm one of the attorneys for Todd Mullis. Would you please state and spell your name for the court reporter?
Yeah, Blake Heeman, BLAKEHEMANN.
Mr. Heeman, where are you employed?
Farm Credit Services of America.
And what do you do there?
I'm currently a sales skill trainer. Previously was a crop insurance agent.
How long have you worked for Farm Credit Services?
16 years.
How
On a
long did you work
1.25.
as insuring crops for farmers?
Approximately 13 years.
So do you have a general understanding and knowledge of like planning practices?
I do.
In your, yes. Is that better? Is that better? You just said you had experience with the planting industry, farmers. Can you give me just a general idea of your interactions with them in your 13 years insuring crops for them?
Sure. The crop insurance process is pretty straightforward. I'd say the biggest requirement is understanding what coverage the producer wants, and then there's some key dates and times that need to be met throughout the year with that process to make sure that they're insured properly.
Do you recall what those key dates are?
There's several. So sales closing date is March 15th. There's some planting dates. So like corn to get full coverage should be planted by May 31st. Beans, I believe, is June 15th. Then there's some other reporting for production in as well. So.
And those are required dates?
Correct.
Is there a window of time planters have to have all of their information submitted?
Yeah, so like acreage reporting, July 15th is the deadline to have that reported.
Who is that required by?
USDA along with the AIPs, the crop insurance agencies.
Are you familiar with the Mullis family?
I am.
Are you familiar with their farming operations?
I am.
Who in the Mullis family are you familiar with?
All of them, the whole family. Todd, I'm familiar with Amy, Pat, all of the whole operation. Mike, Leroy.
And Leroy is the father of the three males that you just mentioned?
Correct.
And you said Amy also, Amy Mullis?
Yep.
And you insured crops and farmlands for those members of the family as well in their farming operations?
Correct.
Okay. Mr. Heeman, can you explain what an acreage farm book is and its purpose?
Yeah. Do you have that example? Or
I'm going to do that in a moment, but just generally.
generally speaking, when the producer comes to us and says, I planted this crop on this day, we map that for them to get it in the system to essentially certify those dates, crops, locations for them.
And this, is it a farm book or a frame book? Forgive me.
I know they're referred to by some maybe as a frame book. We call it an acreage report.
Okay. Is this something that's generally you prepare for each of your farmers?
Correct.
Is that annually you prepare?
Correct. Annually.
Did you prepare an acreage farm book for Patrick Mullis?
I did.
I'm sorry, Patrick and Judy Mullis.
I did.
Do you know what information was included in that acreage book for Patrick and Judy Mullis in 2018, just generally?
Yeah, acres, type of crop planted, and the plant date, along with PAT certification that everything was correct.
I'm going to show you, Mr. Heeman, a redacted report. It's Exhibit 378. And Your Honor, redacted is just the privacy, personal data, phone numbers, social security. The 2018 acreage framework. Do you see that in front of you?
I don't.
Can I give you my copy?
Okay.
One moment. Can you pull up on the screen for me? Give you a moment to skim it.
Your Honor, the court previously received a copy of this on its hard drive if the court needs to see it.
I'm able to access it. Thank you.
Thank you, Your Honor.
I'm familiar with this book.
Because you created that book to put it
Correct.
together.
Yep.
What year does this acreage report cover?
This one says 2019. I'm sorry, 2018.
So just to confirm, the one in front of you covers is report
2018.
2018, is that what you said?
Correct.
Do you know when it was prepared?
Should say on here. This was done on June 12th,
And you said the information is required to be submitted by June 15th?
July 15th.
Okay.
This copy was created on June 12th. I don't know, the copy that I had seen before had a signature on it. This one does not. So there's a chance that we did it before June 12th as well.
Okay. What page? Mr. Heeman, would you turn to page 22? Do you see a signature on that page? Well, a redacted signature.
So on the actual acreage report, this would be a signature area where we would need a signature. If you're referring to the other 578s,
Is that
one
the
you're looking
form?
at? That's a different signature.
What page would that be on?
I don't see the page numbers.
I can't give you a PDF number, so hang on one moment, please. We're going to show you
Sure.
with the court's permission.
Certainly.
Of the electronic document.
Yeah, so that document right there is the certification from the Farm Service Agency. And so that signature would have been the date that Pat certified those acres with the FSA office or Farm Service Agency, which is separate from our acreage report.
Okay. Mr. Heeman, so again, in this report, is there mapping information in there regarding fields that the farmer would own or be affiliated with in renting, for example?
I'm going to object. One, I don't know if we're admitting this exhibit. The state certainly objects to the admission of the exhibit, so right now it's assuming facts, not in evidence. I'm also going to object because it's irrelevant. It's not Mr. Mullis's farm specifically, so under those grounds.
Hey, good morning, Miss King. And this guy kills me how he says the word irrelevant. He says irrelevant.
As well as 5403 prejudice, as it would be misleading.
Did you wish to respond?
Yes, Your Honor. I'm not asking for specific information. I'm asking generally, are there mapping, what is included in that report, just generally speaking, and there will be foundation in just a few more questions, and it's certainly relevant because it gives information to support that certain allegations by the state or testimony in the underlying trial by the state is false, and we'd like to show that with this what the court was about to see?
Well, I mean, at this point, I guess I don't have any information to tell me what these maps or this information has to do with Todd Mullis.
Hey, David.
Maybe we could lay that foundation and then move
morning.
forward with the specific information about this exhibit.
And a few more questions, I think I can establish that.
Sure, why don't we
Yes,
go
ma'am.
there and then we can come back to the exhibit?
Sure.
Okay.
The foundations. Mr. Heeman, do you know who operated the planter for the Mullis family members' fields that you insured the crops for, from your understanding?
From conversations, I was aware,
Objection, hearsay and speculation, Your Honor.
Overruled.
You can answer.
okay. From conversations with the Mullises, there was an understanding that Todd operated the planting equipment on occasion.
Did you have any reason to believe that that information wasn't true?
No,
You actually insured fields for Todd and Amy Mullis and their farming operation, is that right?
correct.
Do you know if Farm Credit still insures Todd and Amy Mullis's, their property that was insured in 2018? Is it
As far
still
as I'm
insured
aware,
today?
yes.
Can you say that again? I'm
As
sorry.
far as I'm aware, yes.
And also Pat and Judy Mullis's property, is that?
Yeah, I'm not in that role anymore, but as far as I'm aware, yes, we do.
In 2018, have you ever met Todd and Amy Mullis before in person?
Yes, on their farm.
Do you know what year that was?
2018, around that time frame, probably more than one occasion.
Okay. Can you just, what was the where did you meet them? What were they doing?
In some cases, it would have been signing acreage reporting documents or other crop insurance documents or deciding what coverage to take. In other instances, just on the farm, stopping in to say hi, see how things were going.
So you saw Amy and Todd Mullis together?
On one occasion, both of them together, yeah, that I can think of.
Okay. Do you notice anything unusual about them together, demeanors?
No.
Odd? Have you ever seen Todd working on a planter or fixing a planter in front of his shop anywhere or on the farm?
On that occasion that I was just speaking of, I mean, when we stopped in, I remember the planter equipment being there. Is about this time of the year. Seems like Todd was working on the equipment, again, in his yard, in front of his shop.
Okay. Okay, Your Honor, I'm going to go back to the showing Mr. Heeman a copy of the redacted report, if that's okay.
You can, I guess let's see what the questions are.
Can I show my report?
It's not. He has a dance.
You have it in front of you?
The paper copy?
Mr. Heeman, this book, again, you prepare for your farmers annually, is that right?
Correct.
About how many farmers or is it farmers or producers that you call them? Either?
Either, yeah.
How many of those did you have at the time you were working in this capacity as a,
Objection, relevance.
Overruled. You can answer.
90, I would guess, somewhere in that ballpark.
so did you create one of these books in the ordinary course of business for your farmers?
Yes.
Your Honor, we'd offer Exhibit 373, the frame book, for, Mr. Heeman, just to clarify, was this book created in the ordinary course of business as your standard practices for your farmers?
Yes.
Okay, Your Honor, the applicant would now offer Exhibit 378, into evidence.
Any objection?
Yes, Your Honor. For the same grounds, it would be misleading. It's more prejudicial than probative under 5403. This is Pat Mullis's farming record, so it's irrelevant to this proceeding and doesn't speak to Todd Mullis's planting habits or even whether or not he was the one planting, even based on the foundational testimony of the witness here. So it is more prejudicial than probative and irrelevant to this proceeding and immaterial.
Again, I guess all I've heard to connect it to Todd Mullis is that on occasion, he operated the planter that I guess potentially planted the crops that would be referenced in this report. So I agree, it's way too tenuous at this point. It's not going to be admitted at this point. If you want to continue to lay some foundation, you certainly can.
Mr. Heeman, between the Mullis family members, there was Mike, Leroy, Pat, Todd, and Amy Mullis. You insured their fields?
Correct.
From your knowledge of all of those fields that are insured, crops are insured, was it that Todd Mullis was the one that operated the planter for those fields?
The primary operator of that equipment, again, through conversations, was
Objection,
always that.
hearsay and speculative, and it's leading, Your Honor.
Overruled.
You can answer.
In those conversations, it was often talked about that Todd was the operator of the planter equipment.
Do you have any reason to believe that he was not the operator of the planter?
Objection, Your Honor. Again, we're just speaking to another farm book. It's completely irrelevant to this proceeding and speculative at this point. If you would like me to voir dire the witness and ask if he has specific knowledge about specific instances, I'm happy to do that. But it is speculative here because it's trying to say it's action in conformity with another document that hasn't been admitted.
You may voir dire the witness if you'd like.
Thank you. Good morning, Mr. Heeman.
Good morning.
You mentioned previously that you insured all of the Mullis family farms. Is that fair?
Correct.
On any specific date and time, were you present when Todd Mullis was planting?
Not to my knowledge.
Can you name any specific date or time as it relates to when he would have engaged in planting on any one of the Mullis farms, specific timeframes?
That I witnessed?
Yes.
No.
So is the full value of your ability to speak to whether or not he planted in his fields or in another Mullis family field based on what you've heard and what has simply been relayed to you?
That would be correct.
Your Honor, the state would object on the same grounds.
Again, 378 is not going to be admitted at this time.
One moment, Your Honor. Could you give me one moment, please?
Certainly.
You said you're familiar generally with farming, planting industry. Have you ever ridden in a tractor before that's pulling a planter?
Objection, relevance.
Overruled.
Yes.
Generally speaking, do you know how fast a planter moves in the field or tractor moves in the field?
Depending on the equipment, it's probably average 5 miles an hour, I would assume would be a good estimate.
Okay. Does the size of the planter impact planting time?
Sure.
How about the shape of the field? Does that affect planting time?
Yes, I mean, a square field that's flat is going to plant easier and faster than one that's got waterways or point rows in it.
Do you know if, do you know the size of the planter that Todd Mullis used when he planted his own fields?
No.
So you don't know if it was a 16 rows, 24 rows?
I'm not familiar with what size it was.
I don't mean to put you on the spot, but do you by any chance, because you're insuring the fields, know how many feet are in an acre?
I should know that.
Oh, you do?
I should know that. I'm sure I knew it at one point. So the answer would be no. Not today.
Hey, Miss Margaret. Good morning.
It's the information generally that is provided in the books that you created. Is that reported to the FSA? Is that what it was?
Okay, so has anyone yet made a determination as to why? Sorry, I'm double glassing it right now. As to why these questions have any relevance at all. Like, what is the purpose of this questioning? I don't understand.
This information in our books, that when we do our crop insurance reporting, our acreage reporting, we're submitting that information to the approved insurance provider, who is essentially the underlying reinsurer, so the company that's holding the insurance.
Hey, Shellbell. Shellbell's like 43,560 square feet in an acre.
Without looking at the book in front of you, do you know the
There you go.
areas of the fields that you insured for several years for Pat and Judy Mullis?
Objection, relevance.
Overruled.
I'm familiar with them, yes.
Do you know the radius between, I'm sorry, let me ask you a different question. How many fields, if you know, without looking at the book, did you insure for Pat and Judy Mullis?
Yeah, ballpark 7, I'm going to guess.
Do you know the radius between those fields?
I would say all within 20 miles of one another.
Okay. When someone is planting, do they need to refill whichever crop they're planting with certain items? For example, fertilizer or?
Yes, the seed, fertilizer, some chemical.
How often does a planter break down, so to speak?
According to the producers I talked to
What does any of this have anything to do? I don't understand it.
much. They have the wear and tear affects them. They do break down, I would say, often.
I just want to clarify one last point. You said it was 2018 that you had met Todd and Amy Mullis,
As far as I can recall, yes.
and at one point you saw them together,
Yes.
and you didn't notice anything odd or about their demeanor or relationship.
No.
Okay. Okay. I have nothing further, Your Honor.
Cross-examination, Mr. Duden?
Briefly, Your Honor. Good morning again, Mr. Heeman. You managed the insurance policies or services for the Mullis family for a number of years, is that fair?
Correct.
And your agency has done this since at least 2018, right?
Correct.
Up to the present?
As far as I know, correct.
And based upon your testimony, you first met Todd and Amy Mullis personally in 2018?
Objection, Your Honor, that's not what he said.
Overruled.
Is that correct?
First met them, I believe that's when I took those policies back over, correct?
And so any paperwork that would have gone through your agency would have been signed by them on their property?
Can you clarify with any paperwork?
When you had them sign or certify the farm paperwork at issue, or that is relevant to your agency, would that typically be done on their property?
Not always.
Did you meet Todd and Amy Mullis on their land specifically, though?
It's on occasion, yes.
And on the number of occasions that you interacted with them, it would have been on their land?
Generally, I would say probably more often than in the office, if that's what you're asking.
And today, you can't say whether or not Todd Mullis engaged in any planting for a family member, can you? On a specific date in time?
Not that I witnessed, personally.
Were you asked to sign an affidavit in this case?
Yes,
Did you sign an affidavit in this case?
I did not.
Why not?
Because the affidavit asked the same question you just asked me, to essentially say that I saw or knew of Todd planting every acre on a specific date.
And you couldn't do that, could you?
I can't.
To the present, does your agency still manage the farm insurance policies for the Todd and Amy Mullis land?
As far as I know, yes.
And as far as you know, that land still is placed within the Todd and Amy Mullis Living Revocable Trust or within their names, correct?
Objection, Your Honor, how would he have that information?
Overruled. The witness can answer if he knows.
I don't know the answer to that, of what it's insured under or who.
So from what I've gathered from your testimony, you knew or believed that Todd Mullis would on occasion assist with planting in his family's fields. Is that correct?
Objection, Your Honor, he didn't say on occasion.
Well, the first time he did use the word on occasion, so the objection's going to be overruled. The witness can answer.
And I can clarify that. So I should clarify, as far as I knew and was told, Todd did the planting of all crops for the Mullises in the past and up to that point.
But that was all based on what you heard from other people, wasn't it?
My conversations with the Mullises.
So it was self-reported.
Correct.
And to date, you've never witnessed that, right?
I cannot recall a time when I witnessed Todd in the planter tractor on a specific field, no.
And even the information that's included as to what date it's planted, planting occurred in any specific year or time frame is self-reported. Is that fair?
It is.
So you aren't cross-verifying that information, right?
Correct, no.
Nor are you certifying that information yourself, right?
We take producer's word for it. They're certifying that that's accurate. Yeah.
I don't have anything else, Your Honor.
Any redirect?
Yes, Your Honor, just a couple, please. Mr. Heeman, if you were to look at Pat Mullis's acreage book, would you be able to determine the fields that were planted in 2018?
Yes.
Objection, Your Honor. Again, we're referring to facts potentially not in evidence, and that has already been deemed or excluded by the court.
Objection's overruled. The answer will remain in the record.
The information about Todd Mullis planting for the rest of his siblings and the Mullis family's members, planting operations, did you have any reason to believe that that information was untrue?
No.
The farmers or producers, you said you take their word for it.
Objection, leading.
You just said that.
Well, is there a
I'll
question?
withdraw, Your Honor. The information that they're providing to you is to get insurance on their crops. Is that correct?
Correct.
Would you say that planting and crops and the yields returned are their livelihood?
It's specific to crop insurance. It's the way they manage risk to ensure they can, again, continue to run their operation.
So they would have every reason to report it accurately. Do you
Objection.
agree?
That's a credibility call and leading, Your Honor.
It is leading. Sustained.
Mr. Heeman, you going to do? I have no further questions, Your Honor.
Any requests?
No, Your Honor.
Thank you, Mr. Heeman. You may step down.
Read this here.
Sure. Further evidence on behalf of the applicant.
Your Honor, I think it might make sense for the parties to confer with the court briefly about scheduling from here.
Okay, let's go ahead. We'll go off the record, take a short break.
Lord, Lord, Lord. I still just don't understand it. I don't understand the whole reason behind. Ay, ay, ay. This questioning. Let's zoom, 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 and a boom, boom. Shake a rope. What is it saying? Court is on break until 2 p.m. Weird. What was that about? Why are they going on break till 2 p.m.? Unless they're having issues with their witnesses or something. I don't know.
All right, Mr. Firehelm, I will just swear you in again quickly since it's a new day. If you'd raise your hand. Do you swear the testimony you're about to give? Try it again.
Recording in progress.
All right, good afternoon. We'll go back on the record.
Hey, shards of words. Good to
Mr.
see you.
Firehelm, are you able to hear me? And you are muted currently. Okay, you are very quiet. Is it possible for you to turn up your volume?
I have it as high as I can get it.
All right, I'll see if we can turn up ours, maybe. All right, would you try it again for me, please?
Yes, Your Honor.
All right, that's much better. Perfect. Okay, counsel, I think we're picking back up with Mr. Firehelm's testimony. Is that correct? Yes. All right, Mr. Firehelm, I will just swear you in again quickly since it's a new day. If you'd raise your hand. Do you swear the testimony you're about to give will be true?
Okay, so the Firehelm the Firehelm dude is, I think, his Todd Mullis's last defense attorney, the one that was on the stand the other day. So he's back again, but only via Zoom. So I don't know if that was what they were waiting on the big long break for, was because of that. But anyway, I feel like we missed a chunk, though, a section of him. She said they were going to take a small break. Hold on, let me go back for a second. Make sure I didn't miss something here by zooming.
All right, we'll go back on the record here just briefly for the purpose of confirming our off-the-record conversation. We've actually been doing remarkably well, I would say, in terms of witness availability. But it's my understanding that at this point, we do have at least a couple of hours before our next witness is available, and we'll be waiting until 1 before the applicant's next witness. Is that correct, counsel?
Yes, Your Honor.
Okay, and at that point, we'll pick back up with the rest of Mr. Firehelm's testimony, and he will actually be appearing by Zoom. Is that the plan?
Yes, Your Honor.
All right. We'll plan on that then. Counsel, I know we have a few things that we can take care of, and you will be working on some other details as well off the record, but we'll plan on resuming in the courtroom on the record at 1 p.m. Anything else then that we need to address by way of housekeeping matters? Anything on behalf of the applicant?
No, Your Honor.
Okay, anything on behalf of the state?
No, Your Honor.
All right, I'll be back in chambers then at whatever point you'd like to address the details that we need to take care of. Thank you. Court's in recess till 1.
Okay, so. All right, then. And that's the plan. So we'll scooch on back to where we were at with Mr. Firehelm. Yeah, they're in Central Time. This is Friday's testimony because I was out all day Friday. We decided to resume so we're able to skip through it shards of words.
All right, good afternoon. We'll go back on the record. Mr. Firehelm, are you able to hear me? And you are muted currently. Okay, you are very quiet. Is it possible for you to turn up your volume?
I have it.
That's much better. Perfect. Okay, counsel, I think we're picking back up with Mr. Firehelm's testimony. Is that correct? Yes. All right, Mr. Firehelm, I will just swear you in again quickly since it's a new day. If you'd raise your hand. Do you swear the testimony you're about to give will be true and correct?
Yes, Your Honor.
All right, and I know that the camera angle is not the greatest, but hopefully you can see counsel well enough. Counsel, if you need to move or adjust yourself in the courtroom, please feel free to do so.
Thank you, Your Honor. Thanks for coming back today, Mr. Firehelm. We appreciate it. I wanted to pick back up discussing the discovery that you were tendered before Mr. Mullis's trial. Do you recall if that discovery included audio and video files?
I believe it did. I'm not 100% sure.
Mr. Firehelm, for some reason we lost your video. I'm not sure. There you're back. Okay.
Do you recall specifically audio and video of an interview with your client, Todd Mullis, November 16th, 2018?
If that was the interview by DCI, I believe he was at the law enforcement center. Yes, I do.
Do you recall reviewing one of Tristan Mullis done by DCI, November 16th, 2018?
I think so, yes.
And are you familiar with investigative techniques such as the Reed technique?
Yes, I am.
And is it your understanding that the Reed technique is designed to obtain a confession from a suspect?
I believe so, yes. That's my reading of it.
Did you consider or investigate whether the DCI agents were utilizing such techniques on Todd Mullis and Tristan Mullis?
I didn't match up their technique with the Reed technique, although I've seen DCI use it pretty consistently.
And Your Honor, I'm going to object on this point solely for the fact that evidence already within the record has testimony that's been uncontroverted essentially at this point. As Special Agent Turbot testified, he did not use the Reed technique, if I remember correctly.
Overruled.
Mr. Firehelm, I think my question really is that you had some education or knowledge about interrogation techniques at the time you represented Mr. Mullis?
That's correct.
And did you take any actions or conduct any investigation to have those interviews reviewed by somebody more knowledgeable than you?
No.
Could you have consulted an expert regarding coercive interviewing techniques?
Yes, yeah, they're expert for everything.
Did you consider investigating or locating any witnesses that could testify to Todd's good character?
I didn't. Bob had a lot more contact with local people and family than I did.
Great, thank you. I know yesterday we talked a little bit about the 911 call that the state played during trial. Do you remember that discussion?
Yes.
Do you recall if you listened to it before trial?
Yes, I'm certain I did.
And then do you recall ever playing it for Mr. Mullis?
I do not recall doing that, no.
During Mr. Mullis's cross-examination, did you consider objecting to the mischaracterization by the prosecutor that Todd was alone at the time of those purported statements?
No, I don't think so.
Did you investigate the timing of the purported statements in order to contradict that state's argument?
Are you referring to the cross-examination questions or that claim by the prosecutor that he was whispering something to her? Is that what you're referring to?
Yes.
That wasn't an issue. There was no warning about that at all until it happened.
And so you weren't able to look into the timing of those statements?
No.
If you had had notice of those statements, could you have done some investigation to learn whether another deputy or another person was on scene at that time?
Well, I think it was pretty clear there was another deputy on scene. There was back and forth between Todd and the deputy before that allegedly happened.
Okay, and you didn't point that out during trial?
Again, it came up right there at the end in almost the last question she asked him or presented it to him. So no, I didn't.
Thank you. I'm going to move on now. Do you remember the name of a witness, Tom Krogman?
Yes, I think so, yeah.
Do you recall there being a DCI interview that included audio?
I don't. I'm not saying there wasn't, I just don't recall it right now.
Do you recall, in your review of the discovery, DCI agents telling witnesses that the medical examiner's opinion was gospel?
I don't remember that being said.
Did you consider calling Mr. Krogman as a witness at trial regarding his observations during the emergency medical services on the side of the road or his observations at the hospital?
I don't think so, no.
Do you recall an email between you and Mr. Sabers about whether you should call Mr. Krogman?
Not specifically, no.
Just a moment, Your Honor. I think I'd like to refresh the witness's recollection, but between the Zoom and the sharing, I need just a moment here.
Okay, just let us know when you're ready, please.
Your Honor, at this time, we'd like to share our screen to show an email to Mr. Firehome, but we're not seeking to admit it. It's just to refresh his recollection.
Okay, is this something that has been marked as an exhibit that we can refer to for the record, or?
It is not, Your Honor.
All right, counsel, are you aware of what's being displayed to the witness?
Yes, Your Honor.
All right, go ahead.
For the record, Your Honor, I think our next number is 977. Mr. Firehome, can you see that?
Yes.
If you would just review it and let us know when we can take it down.
Okay.
So did Mr. Sabers and you discuss calling Mr. Krugman as a witness for Todd?
That was September 13th, I think.
Hey,
There was
honey,
such a
good to
flurry
see you, honey.
of emails going back and forth, and I don't specifically recall that one, but I do now remember Bob bringing that up, and I don't know if we talked on the phone or just traded the emails about it.
And that would have been right before the trial started. Is that your recollection?
Yeah, just a few days before.
I want to move on a little bit here and ask, are you familiar with the field of biomechanical engineering?
No.
Do you
I know what it is, but
Hey, Chrissy.
I'm sorry.
I'm sorry I interrupted you. I know what it is, but I'm certainly not an expert or that knowledgeable in it.
Did you consider consulting an expert in biomechanical engineering to investigate whether Amy could have sustained her injuries in a fall?
No.
Did you consider or investigate the principles of force that could be generated from a fall versus a strike or a swing of the rake?
I did not.
I want to show you Exhibit 233, which we looked at yesterday. It's a letter from Mr. Mullis to you. I understand, I think it's undated.
I can see it, yes.
Okay, thank you. And if we can scroll, I think it starts on page 3 and 4. They're very small for me.
Hey, pen pal, good to see you. Hello, hello.
Did you understand Mr. Mullis to be asking questions here about investigating a theory that Amy died from an accidental fall?
Certainly that's what he's referencing there in the photos or the drawings that he made. But I don't know when. But without a date.
Would you agree that this would be a letter that Mr. Mullis sent you before trial?
Oh, yeah, yes.
And do you recall Mr. Mullis asking you to investigate how the far right tines did not come out of Amy's body?
I don't remember that specific question, no.
could go to the first page, bottom paragraph. Could you review that for me?
Okay.
Would you agree that Mr. Mullis is asking you to verify the possibility of it being an accident?
That's what it says, yes.
And then on the second line, was totally out of the far right wound?
That's what it says.
So would it be fair to say that you weren't considering, the principles of physics or Newton's law of motion when you reviewed the autopsy report?
Excuse me, can you say that again?
Sure. Is it fair to say, based on your prior testimony, that you weren't considering the laws of physics or like Newton's law of motion when you reviewed Dr. Cruz's autopsy report?
No, I wasn't considering that type of technical analysis.
And because we're lawyers, that's why we would hire an expert.
Yes,
If you had had evidence before Mr. Mullis's trial that a swing of the corn rake could not have generated enough force, would you have presented that to the jury?
well, I guess you start out, if we had that, if evidence or witnesses are helpful to a case, of course you present it.
And if you had talked to an expert and that expert explained to you that the laws of physics made it impossible for the corn rake to have been swung into Ms. Mullis, would you have presented that to the jury?
Based on that hypothetical, yes.
If you had evidence that it was impossible for the corn rake to have been pushed or kicked into Ms. Mullis, would you have also presented that?
Same answer.
Did you present any evidence that Mrs. Mullis' death was the result of an accidental fall?
No.
And when Todd took the stand to testify, did you ask him any questions that would support that Ms. Mullis' death was the result of an accidental fall?
There may have been some questions about what he told law enforcement and medical people right after this happened, but I don't recall, I don't think there would be any other place in his testimony or I would have questioned about that.
Did you present any testimony or evidence about the prescription medications that Amy Mullis was taking at the time of her death?
I don't think so.
Did you consider or present any testimony or evidence that Amy Mullis was anemic at the time she died?
I don't think so. Todd may have testified about her being weak and dizzy when she was out in the barn helping get things cleaned up, but I don't remember if there was any specific evidence about any medical reports or evidence about her being anemic.
Do you recall in your opening statement telling the jury that Ms. Mullis was deliberately and viciously murdered?
I don't know if I use those words, but yes, that's what I was telling the jury.
Okay. I want to circle back to the text message evidence that was presented at trial. Do you remember there being text messages as a topic with quite a few witnesses?
Yes, I think so.
Do you recall there being witnesses who testified that Amy was unhappy or scared of Todd?
Yes.
Did you obtain copies of the full text messages or cell phone records for Amy and Todd Mullis?
I don't think we had 100% of the records to know if that's what you're asking.
If we could show the witness Exhibit 307, the first 18 pages only. Mr. Fireholm, do you know if you've seen this document before?
The best answer I can give is I don't think so.
If there are text messages between Todd and Amy that contradicted what witnesses said at trial, would you have used those?
I'm not sure what you mean by contradict.
Would you characterize the state's evidence as attempting to, paint a picture of discord between Todd and Amy or tension?
Your Honor, I'm going to object on the grounds of 5403 and relevance. This evidence is not admissible, and so it's immaterial, but it's also a report that was generated by Mr. Castle and wasn't a part of the underlying record at the time Mr. Fireholm even represented them.
I guess, Ms. Nichols-Cook, did you want to respond to that?
Well, Your Honor, it's already admitted. I am not asking this witness to admit it. It's the whole point, right? He didn't have this information because he didn't request it, and he could have used it to impeach the witnesses at trial that talked about messages with Amy that the state relied on.
Right. Kelly, can you read me back what the question was?
Would you characterize the state's evidence as attempting to, paint a picture of discord between Todd and Amy or tension?
Yeah. The objection's overruled.
Mr. Fireholm, do you need the question again?
Please.
Did you understand the state's evidence at trial, or would you characterize it to be attempting to show that Todd and Amy were unhappy, or that there was tension in their marriage and in their home?
Yeah, I think that's fair.
So we're going to scroll down here. What page? Page 14. And I think I can direct you to line 233. And then 234 after it.
You need to scroll a little bit. I can't see 233. Okay.
Can you tell me what the dates are for line 233 and 234?
October 14th, 2018.
And this would have been shortly before Ms. Mullis passed away?
About a month.
And would you agree that the content of these messages contradict the state's narrative?
Yeah, those two do, yes.
Okay, we can take that one down. Mr. Fireholm, did you take any steps to impeach or discredit the witnesses who testified at trial regarding Todd and Amy's relationship?
Well, I guess the record would speak for itself. I think we cross-examined them, but I don't recall specifically.
I'm sorry. Did you take any steps to determine if Amy Mullis had a Facebook account?
I don't remember.
Could it have been helpful to you to present evidence from Amy that her and Todd were happy?
Yeah, I suppose it could have been interesting or relevant to the jury, inconsistent with what was going on, but
So, Mr. Firehelm, do you recall reviewing phone records from Terry Stainer?
I might have, but I don't think so.
Do you recall Terry Stainer's testimony at trial?
Not in any way I could talk about it today.
If I represented to you that the transcripts indicate that Terry Stainer was testifying about Amy being upset or scared of Todd, or that she testified about Amy saying, "Look for me in the timber," would you agree with that?
Yes, I think so.
If we can show the witness 372. Do you know if you've ever seen this before, Mr. Firehelm?
The best I could do is I don't think so.
And can you tell what it is?
Hey, no worries, Donnie. No worries at all, ma'am. Look around. Look around. This attorney, I'm gonna say real quick right now, I feel like his current defense is making this dude, which is his previous defense, look like a not so great attorney. You know what I'm saying? I feel like they're going with the whole like ineffective counsel or whatever. I mean, that's just my personal opinion. He doesn't seem like he did much to, but then again, I didn't see the original trial. I just feel like based on what they're asking him now, he didn't do any and everything he could to get the dude off. So.
It looks like phone records, and at the top it says David Stainer.
If these phone records would have impeached Terry Stainer, would you have used them at trial?
Sure.
If they would have discredited her about Amy coming to her house crying in October 15th, 2018, would you have impeached her with proof that Amy didn't?
Sure, anytime you can discredit a witness, you try. I don't know how this would do that, but yes.
Okay, we can take that one down. Mr. Firehelm, do you remember a witness by the name of Corey Volker?
I don't recall that name.
You don't recall any investigation into Mr. Volker's relationship with Amy?
I'm not connecting that name with her, no.
Do you recall having in discovery text messages between Amy and Corey Volker?
I'm not recognizing that name.
Would you be surprised to learn that Mr. Volker knew about Amy's affair with Jerry Frazier?
Again, without picturing him or linking him somehow, I'm at a loss here.
We could show the witness 268. So, Mr. Farham, can you look at this and tell me what it is? To the best of your, I guess, ability to identify it.
It's SMS text messages. It says Corey Volker.
And have you ever seen this before?
So
Okay. Okay, we can take that one down. Do you remember there being witness testimony about Amy screaming and getting into a fight or being upset with Todd? Oh, looks like Mr. Firehelm is frozen.
Mr. Firehelm, are you able to hear us?
yes, I can.
Okay, looks like your video is frozen.
I don't recall a screaming match between Amy and Todd, no.
Do you recall any text messages about Amy screamed?
I'm not recalling it today, no.
And did you do any investigation to determine the facts surrounding the text messages the state presented at trial?
No, I don't recall at this time.
Mr. Firehelm, you might want to turn your camera off and turn it back on. It looks like you're still frozen here, but we can hear you.
Right now, I've lost that bar at the bottom where I can turn things on and off. All I have is that exhibit in front of me right now.
Oh, we've taken the exhibit down, so I am not sure what advice to give you. Oh,
You see me now?
yep.
Okay.
We're back. We talked a little bit yesterday about Todd asking you to have the accident theory investigated. Do you recall that?
Yes.
And I wanted to clarify if it was your testimony that Todd Mullis was just shotgunning, and if you could explain what that characterization means.
Well, Todd would write these long letters. Well, not all of them long, but there was a lot of it. And there would be ideas or questions and so forth. And like I said, since I couldn't email him back, we would either when I went to see him at the jail or when we talked on the phone, we would address those things. And that's how I kind of interpret Todd told me and Bob, you know, I'm just sitting here, I'm thinking, I'm putting these things out there. That's kind of what I meant.
Okay, that helps.
I didn't mean what he was doing was inappropriate. It's just that's kind of the methodology that went on between the three of us.
Do you recall answering Todd about whether the two tines ever came out of the right two wounds?
I don't remember that type of specificity. I don't think we did, no.
Would you say that Todd consistently asked you about evidence that Amy's death was the result of an accident?
Earlier on, yes, and maybe continuing for a while, but I don't think that was a big issue as we came down the stretch towards the trial.
Do you recall testifying in your deposition that Todd never stopped asking you to investigate whether it was an accident?
I don't recall that specific question, no.
We can. We will show you your deposition, Mr. Firehome, just a moment here.
I have it here if you want to give me a page.
Yes, if you could turn to page 23 and look at line 5.
23?
Yes, page 23, line 5.
Okay, I see it.
And so in your deposition, you testified, no, Todd never stopped asking about experts in an accident theory?
That was my answer, that's correct.
Okay. I want to touch on communication with Mr. Mullis briefly. I believe you said you testified that Todd would call you from the jail before trial?
Yeah, I remember there were phone calls, yes.
Did you have concerns about the confidentiality of those phone calls?
I don't remember if the jail staff assured us that they would be confidential or not. I think they did, but I'll answer your question. No, I didn't have a concern.
So do you recall telling Todd that you couldn't say a whole lot on the calls when he would call you?
I don't remember that, no.
Do you know if you scheduled legal calls at either the Buchanan or Dubuque County jails?
I really, it would just be a wild guess. At Dubuque, we would have had to have done it in the evening, and I think I was there, but I'm pretty sure it was more than once. I know the night before the trial started, I went there on a Sunday night, but I think there were more than that.
I want to pivot now to your opening statement at this trial. Did you discuss that with your co-counsel, Mr. Sabers?
I think Mr. Sabers was there the night before the trial started. And whether or not we talked about the opening statement, I don't remember.
Do you remember testifying in your deposition that you didn't give him a copy or a draft of your opening?
That would be accurate. I don't remember specifically in the deposition, but that would be true.
That night before trial began and you met with Mr. Mullis in the Dubuque County Jail, did you tell him what the substance of your opening statement was going to be?
I don't remember.
Okay, I want to pivot again. I'm sorry. I feel like I just keep jumping. You testified yesterday that you visited the Mullis farm, and I believe that you looked into the shed and kind of in the farmyard.
We went to the shed where this took place, and I don't think we went into the other buildings, but Glenn and Mike pointed out, I'm pretty sure Mike was there, what the other buildings were, and like, there's the 2 hog barns, there's the machine shed and so forth. And then I think it was just Lynn and I went in the house and sat and talked.
Do you recall taking any steps to learn what Amy was doing before her death in the hog barn?
What she was doing in the hog barn,
Right, before she went to the shed?
just what just what Todd and Tristan testified to. And that's what Todd had told me in our conversations.
So, do you recall there being injuries to Amy's right hand?
I don't recall specifically, no.
Do you recall doing any investigation to determine if they could have been caused by cleaning the light fixtures in the hog barn that morning?
There was no investigation as to that, and I don't remember Todd or Tristan saying that that had happened. Todd said he was concerned about her balance and she was trying to do too much after this medical procedure.
So, Mr. Firehelm, I should have shown this to you yesterday, so I apologize, but this is demonstrative 275. I don't know for sure which camera I'm trying not to cough. Do you know if you've ever seen this before? We're going to try another camera. Do you know if you ever saw this before?
I don't think so.
Did you ever consider if Amy was cleaning these and putting her hand in there that it could have created injuries on her hand?
Objection, speculation.
Sustained.
Did you ever consider if the hog barn light fixtures could have caused an injury to Amy Mullis's hand?
No.
Thank you. Thank you, Tom. Do you recall doing any investigation into farming accidents as a theory of defense?
No investigation into that, no.
Do you recall examining the corn rake that officers seized from the farm?
During the trial, yes.
But not before. Is that what you're telling me?
Yes.
So did you see the blood on the handle of the corn rake?
Not before the trial.
Did you take any investigative steps to determine how the blood would have gotten there or whose blood it was?
No.
Do you recall Todd asking you in letters to look at the rake and the physical evidence?
I think he did, yes.
Did you ever look at Amy Mullis's clothing from November 10th, specifically the coat, the sweatshirt, and the long sleeve shirt that she was wearing when she was injured?
No.
Did you take any investigation into the holes in the clothing in relation to Amy's injuries on her body?
Well, when you say investigation, I mean, there were photographs in the reports that were made part of the discovery, but any specific investigation or having some independent person look at them and so forth, no.
Did you take any steps to reconcile Dr. Cruz's opinion that the rake would have been swung 2 to 3 times, but there were only 4 holes in the coat?
No, I don't think so.
And Mr. Firehelm, are you looking at your deposition? I see you're looking down.
I have it right here in front of me, yes.
Okay. Do you recall looking into the security camera system at the Mullis farm?
There's either Mike or Lynn showed it, the one camera over in the machine shed, I think, that was not functioning.
Do you recall testimony from state witnesses that the security cameras were not working November 10th, 2018?
I don't know if they testified that all security cameras were, but the only one I remember there being concern or testimony about was that one. Because I think it would have been directed towards the shed where this happened.
Do you recall Deputy Himsath testifying that the cameras had been turned off?
I think he did, yes.
If you had evidence that Todd was not on the farm when that happened, would you have presented it to impeach Deputy Himseth?
I'm not recalling Himseth's exact testimony about whether or not he thought Todd turned him off or when they got turned off. So I don't know how I would have used it.
Do you recall an inference that in committing murder, Todd would have turned the cameras off that the state was trying to make?
Well, yeah, I think they were trying to create whatever inference they could.
And if you could have rebutted that inference, would you have?
Sure.
Did you do any investigation to determine whether Amy Mullis or her boyfriend Jerry Frazier could have turned off their surveillance cameras to hide their affair?
No.
And you didn't consult any expert about the surveillance footage?
No.
And do you remember doing any investigation as to whether the camera lost signal versus things were deleted?
No.
Okay. I think yesterday we talked a little bit about hearsay objections and your motion in limine. Do you remember that?
Yes.
Did you know that by failing to make an objection during trial that you were waiving that issue for appeal?
Yes.
Did you have any discussions with Todd about waiving that appellate issue?
No, I don't think we did.
If the transcripts reflect that you didn't make any hearsay objections during the testimony of Terry Stainer, would you agree with that?
I think I would, yes.
Would the same be true then for Patricia Christopherson
I think so.
and Carrie Callanan?
Yes.
Okay. Do you remember discussions with Mr. Sabers about seeking a change of venue for the trial?
Yes.
Let me start over. Was venue changed from Delaware County?
Yes.
And where did it go?
Dubuque County.
Did you consider asking for an additional change of venue from Dubuque County?
I don't know if we considered filing another request. I think Bob actually maybe was the one that made the comment that we had gone from the frying pan into the fire as far as publicity and so forth.
Did you know if both Delaware County and Dubuque County share a media market?
Yeah, well, I know that from growing up, the Telegraph Herald comes out of Dubuque, the daily paper, and the Waterloo TV station cover, I think, both counties.
Do you recall expressing frustration to your co-counsel that a jury in Dubuque was not going to be any more neutral than one in Delaware?
I don't know if I said it or Bob said it or we both did, but that's certainly.
Did you have any considerations about whether a jury in Dubuque would have a fair cross-section representation of jurors?
I don't know if that was a comment maybe made by the trial judge or by somebody in the room, so to speak, that it was just a more populated county than Delaware.
Do you remember considering or researching whether farmers are excused from jury duty in September due to harvest?
I didn't research it, but I've certainly had trials where farm chores and field work came up as an issue about whether or not a person stayed on the jury or not.
Do you remember any investigation or research into what kinds of jurors you thought could be fair and impartial?
I just relied on my experience.
Do you recall investigating whether Todd was planting crops or harvesting
Hey,
at the time
Cherie.
of any of the Google searches that the state attributed to him?
Thank you for leaving your thumbs up.
Well, I know certainly Todd told us that, which I think was confirmed by Mike or Lynn or both.
Did you do any investigation or seek any documents that would have confirmed Todd was operating the planter in April and May of 2018 during these questionable Google searches?
No, I don't think so.
Are you familiar with the Farm Acre Book and farm insurance?
Familiar with what?
A Farm Acre Book and the concept of farm insurance? Crop insurance, I'm sorry.
No, I'm not.
If you could have produced evidence that Todd did not have access to the iPad or the internet on the dates of those searches, would you have presented that at trial?
Yeah, sure.
Do you recall telling the court that you had a family issue come up during this trial?
Yes.
And would that have been distracting to you?
It was concerning, yes.
I want to talk a little bit about Jerry Frazier and your references to him or your plan with regards to evidence about Jerry Frazier. Do you remember who he is?
Yes.
Do you recall in your deposition explaining that you were going to point to him as a possible perpetrator that was part of your plan?
Yeah, I think so.
Did you have any evidence that supported that Jerry Frazier had come onto the Mullis farm November 10th and attacked Amy?
I don't recall that.
Do you recall deposing Jerry Frazier?
Yes.
Do you recall whether he had an alibi for the time that she was injured?
I believe he did.
Did you have any other evidence that you were going to present at trial that supported Jerry Frazier being the perpetrator?
Nothing other than his relationship with Amy.
Did you have any other evidence to present that someone else was on the farm that day?
No.
Do you recall your closing argument?
Not really. Not any specifics.
Do you recall arguing that it was a murder mystery?
Yeah, Donnie,
I-
it is.
I might have said that. I don't know.
Would you defer to the transcript?
Yes.
Have you ever challenged chain of custody or contamination of evidence in a criminal case?
Yes.
In your representation of Mr. Mullis, did you investigate how the corn rake was handled by law enforcement?
I don't recall doing that, no.
Do you recall considering whether additional forensic testing of the rake could be helpful to you?
I don't recall considering that, no.
Can I have just a moment, Your Honor? I think I might be done.
You can.
I'm going to step away and lock my front door so we don't get interrupted.
Okay, thank you. fire home my last question. Do you remember there ever being a time that Todd Mullis agreed with you that Amy's death was a homicide?
I don't think he ever said those words, no.
Nothing further from the applicant, Your Honor.
Cross-examination, Mr. Duden?
Yes, Your Honor, but I wonder if now's maybe a good time to take an opportunity for a bathroom break and to reset. If possible, we could take like a 10, 15-minute recess, if that's okay.
We certainly can. Let's go ahead and
Okay, you guys, they're going to go ahead and take a quick 15-minute break. I'm going to zoom through it, and then I have kiddos math class starting in a couple minutes, so I'll be away from my computer, but on my phone, what was the timestamp? I saved the timestamp. What was that timestamp? 5:27:25. Here we go. All right.
Or rape.
Okay. Looks like they started.
Or rape, for instance, as well.
They started the stream a couple minutes after. I mean, the camera didn't start back in the courtroom, I guess, until after they'd already started the cross. But I'll see you guys back here in just a few minutes after her math class is finished. Okay. I still have this on 1.25. Let me scroll through, make sure there's no like long sidebars, or there is something a little bit later, but okay, we're good. We're golden. Let's go. Be back in a few.
As sex abuse and things like that as well, yes?
Correct.
So you have a wide array of experience for high-level felonies and trying those cases. Is that fair?
Yes.
So turning your attention to this case specifically, it's fair to say, I think at this point, you would agree that you represented Todd Mullis in this case, right?
Correct.
When did you begin representing Mr. Mullis?
Probably in March 2019, I think.
If I told you that I believe you appeared in the case around March 8th of 2019, is that right?
That sounds right.
And so you appeared shortly after the criminal complaint alleging that he had committed murder in the first degree was filed, right?
Correct.
As you mentioned on direct examination yesterday, I believe you said that you were referred to this case in order to assist Mr. Sabers. Is that fair?
Yes.
Why did Mr. Sabers need assistance in what was your understanding?
That he did not have jury trial experience at this level of offense.
And so it's fair to say that your experience would be an aid to both Mr. Mullis and Mr. Sabers in trying the case. Is that right?
Yes.
But you did not outright assume the case. You first met with Mr. Mullis' family. Is that fair?
Yes.
That included his sister and brother, I believe, right?
Yes.
And at that time, you talked about the case, right?
Yes.
You also viewed and inspected the property where the murder occurred, right?
Correct.
Is it safe to say that after you drove from I believe your office is based in Des Moines, to Delaware County, that you spent a sufficient or extended period of time discussing the case before taking on any representative role?
Yes.
Did you also speak with Mr. Sabers before assuming the role of counsel in this case?
Yes.
And of course, did you also speak at length with Mr. Mullis?
Yes.
So ultimately, you appeared in the case, but by that point, you'd spoken to multiple people about the facts and circumstances surrounding Amy Mullis' death and Mr. Mullis' charges, right?
Yes.
At all times during your representation, taking it from a big approach or kind of a macro approach before we go to a micro level, you maintained that Mr. Mullis was innocent and did not murder his wife, didn't you?
That's correct.
So at no point in time did you encourage Mr. Mullis to plead guilty, is that fair?
Yes, that's very fair.
At no point did you encourage him to plead to a lesser offense level or level of murder or manslaughter, for instance?
No, sir.
So at all periods of time, I believe, is it safe to say that you believed Mr. Mullis was innocent?
That's correct.
And that's what you held out to the jury over the course of this trial in this case, correct?
That is correct.
So in your investigative steps, as we kind of work our way up towards the trial, again, you interviewed Mr. Mullis's family, yes?
Yes.
And you regularly kept in contact, in fact, with Mr. Mullis's siblings, who were assisting in providing information and conveying information between you, Mr. Sabers, and Mr. Mullis, who was very active in his case's defense, right?
That would be correct.
You reviewed letters,
Yes.
took phone calls, is that right?
Yes.
Not just from Mr. Mullis, but also from his siblings or family.
Yes.
And in this period of time of about 6 months, it was not just at the beginning that you took these steps, but you followed that all the way through to trial as well, correct?
Yes.
Now, directing your attention to what has previously been marked and admitted as State's Exhibit F in this case, I believe Mr. Bakke is going to put it on the screen for you if that helps as well.
I have it in front of me.
Perfect. Well, we'll jump right in then. Do you see the email correspondence marked as Exhibit F on your screen as well?
Yes.
Now, would you agree that this is an April 6th, 2019 email from you to your co-counsel in this case, Mr. Sabers?
Correct.
In directing your attention specifically to what is the first paragraph, let me know if I read this correctly. After again reviewing the medical examiner's report and the photos we do have, I'm almost certain that her death was not a result of accidentally falling on the fork. The number of puncture wounds, the fact that she had several layers of clothing on, the abrasions on her chin/jaw, abrasions on her hands that I will bet will be described as defensive wounds, all lead me to conclude it was a homicide. Did I read that correctly?
You did.
So, less than a month after you appeared in this case and the trial information was filed, this email would suggest that you believe that this was a murder, in fact. Is that fair?
Yes.
And you conveyed that to your co-counsel, right?
I did.
But this wasn't the last time that you conveyed to Mr. Mullis or even anyone interested in the case from Mr. Mullis' side, including Mr. Sabers, that you believe this was a homicide, correct?
That is correct.
Is it safe to say that you conveyed that you believe this was a murder with some regularity?
Yes.
To your knowledge, and based upon the notes, do you believe that Mr. Mullis was not supportive of proceeding with that avenue of defense at trial? Put another way, did you have any indication Mr. Mullis was not comfortable with you conceding this was a murder, but that it wasn't him?
I believe he conceded that.
That you were empowered or permitted to go to trial and argue that this was a murder case?
Objection, Ms. States of prior testimony today.
Overruled, the witness can answer.
Could you ask that again, please?
Is it possible to read it back? I apologize.
That you were empowered or permitted to go to trial and argue that this was a murder case.
Could you hear that, Mr. Firearm?
No.
Oh, so I believe the question was, so you were, in your mind, empowered or permitted to concede at trial that this was in fact a murder, right?
Correct.
To your recollection, do you have any knowledge or recollection of Mr. Mullis telling you that you needed to correct your opening statement during questioning or the examination of witnesses?
No.
To your knowledge or recollection, do you believe that Mr. Mullis ever told you not to again say that they believe this was a murder in its closing?
No.
And do you recall that Mr. Mullis himself agreed that this was a murder on cross-examination at trial?
I believe he did.
So is it safe to say that it was undisputed that this was a murder and not an accident during the trial proceeding?
I'm going to object and ask, the question is vague. Undisputed by who, maybe would help?
Mr. Duden, did you wish to clarify your question?
Sure. So is it your understanding that you, your co-counsel, and Mr. Mullis agreed at the time of trial and throughout that this was a murder case.
I'm going to continue to renew my objection. I don't think this witness can testify as to what Mr. Mullis agreed or what Mr. Sabers thought.
Overruled.
I don't recall either of them disputing or arguing with me about that approach.
And to be fair, as you said earlier, Mr. Sabers, in your opinion, lacked the experience in order to be able to try this case, so you became lead counsel, right?
Correct.
Mr. Sabers did not examine any witnesses at trial, right?
He did not.
He didn't do an opening statement,
No.
nor did he do a closing argument, did he?
No.
So at all points during the trial proceeding, you were representing Mr. Mullis.
Yes.
Now, looking back at State's Exhibit F specifically, I'd like to direct your attention to what is paragraph 2, where you say, quote, I expect we would need to have our expert take a look at the state's examiner's work, but I'd be surprised if he disagrees. Our money may be better spent on getting a good private investigator involved, close quote. Did I read that correctly?
Yes, you did.
So even early on in your representation, you were considering hiring medical experts, weren't you?
Yes.
And you were considering hiring private investigators, right?
Correct.
And you were going to investigate this case with the help of experts if it was necessary, weren't you?
That's correct.
But is it fair to say that during the course of your investigation, in your professional opinion with 45 years worth of experience now, that you didn't believe those experts were needed?
That was my conclusion.
Looking to the course of your investigation, you did, however, look at all of the law enforcement reports in this case, didn't you?
Everything that was provided, yes.
You reviewed transcripts of witness statements, right?
Yes.
You received and reviewed audio recordings or video footage when it became available to you, yes?
Correct. Correct.
And you conducted depositions, right?
Yes.
Before those depositions came to be, though, you also looked at this case from the perspective of electronic evidence, right?
Yes.
You actually reviewed Cellbrite phone data, or Cellbrite phone dump, for lack of a better term, that was provided to you by DCI and by the Delaware County Sheriff's Office, yes?
I believe so.
That information included a review of things like the iPad in this case, right?
Yes, it did.
As well as phone records when it was necessary or relevant, yes?
Yes.
And again, you reviewed all of that information.
Yes.
Looking to your depositions here, I believe you conducted around 16 depositions of potential state witnesses before trial, right? Around that number?
That sounds about right.
You conducted depositions of lead investigator, for instance, Special Agent Turbett.
Yes.
And if you recall, when you deposed Special Agent Turbett, you did so with the view that you were also going to ask about potential other suspects in the case, right?
I think so, yes.
And is it fair to say that during that deposition, you also asked about a potential affair between Amy Mullis and sheriff's deputies from the Delaware County Sheriff's Office?
I think we got into that, yes.
And so now that individual's name, I believe you know to be Rowley as a last name, as well as potentially others, right?
I think that's right, yes.
And do you have any reason to doubt that in Special Agent Turbett's notes, he referred to Rowley as Raleigh with an A instead of an O? Does that sound or ring a bell to you?
Yeah, it kind of does ring a bell, yes.
And in fact, you asked about those circumstances in that report when you deposed him, fair?
Yes.
Drawing your attention to what's previously been marked as State's Exhibit G, do you have that exhibit in front of you, Mr. Firehelm?
I do.
And to be clear, would you agree that this is a chain email or correspondence between you and your co-counsel, Mr. Sabers?
Yes.
And would you agree that both of the messages depicted here fell or came from, were sent on Thursday, April 4th, 2019?
Yes.
So starting with your message, which is the smaller paragraph section on the second half of the page, you wrote to Mr. Sabers that you expressed concerns about irregular injury patterns, marks on the hands and arms, the large abrasion on Amy Mullis's chin or jaw. Those are one of the concerns you shared, right?
Yes.
You also mentioned that you had reviewed at least her medical information and the specifics about a bruise on her arm that was from an IV site from a medical procedure she had days before she died, right?
Yes.
So you had accounted by this point for her various injuries that led to her cause of death.
Yes,
And again, this is when you also were evaluating the potential claim of defensive wounds or injuries that were not from the puncture wounds to her back from the corn rake.
correct.
This also notes that you went to go visit Mr. Mullis in person, right?
Yes,
And if you go to the third paragraph, it also shows that you reviewed the statements taken by individuals that you were asked about on direct, including Patricia Christofferson, right?
yes,
And an individual by the name of Jerry, who ultimately was a subject of the case, or Jerry Frazier, is what you came to understand, right?
yes,
So at this point, is it safe to say you were looking at this case from other potential suspects, right?
yes,
And matters that of what happened months before even this case began.
yes,
And so you knew about people who were supportive of Amy Mullis, for instance, or her friends in their statements, right?
yes,
And you knew that they would potentially testify in this case too. Fair?
yes,
If you flip to the second page of State's Exhibit G as well, there's a message dated also from April 4th there from your co-counsel, Mr. Sabers, directed towards you as well, correct?
yes,
And in that message, you also discuss the autopsy report and accompanying photos, correct?
correct.
And you even discuss down to the depth or distance between certain wounds, correct?
Yes,
And as we noted from your prior message, you shared a lot of these concerns, but these would potentially come to fruition to say that there was potentially more than one strike or swing, I think is how it was referred to on direct, right?
yes.
I'm sorry, can I, objection, what portion of G are you looking at? Two?
The page 2, the full
What is it,
paragraph of text.
what line says swipe or swing?
Oh, that was a paraphrase, a characterization used from the direct examination testimony, Your Honor.
I'm going to object to a characterization of swipe because I don't think that word was used.
Okay, I guess the record will speak for itself. We'll move forward with a new question, I believe, at this point, unless there was one pending. Mr. Duden, did you think you had a question pending?
Possibly, maybe, I don't know. I can ask another question.
All right, let's do that.
When we had discussed a swipe or a swing, for instance, what we're really referring to is the puncture wounds, right?
Correct.
And those would be known as the 6 wounds caused by the corn rake to the back of Amy Mullis's body.
Yes,
Looking to the responsive message from Mr. Sabers to you on page 1, that big block of text, do you see that?
yes,
And in this text, if you'd like to review it, you also noted, you substantially discuss Jerry, right?
yes,
And the other individuals, including a possible sheriff's deputy who Amy Mullis would have had an affair with, right?
yes,
So is it safe to say that even at the earliest point of this case, you were considering other people who could have murdered Amy Mullis?
yeah, this was very early on, beginning of April.
If you look down as well, you let me know when you see the information regarding the DNA evidence.
I see it.
In the individual at the latter third or so of that block of text, it says, quote, "I doubt that investigators did anything by way of looking for DNA in there. And by now I suppose the scene is compromised," close quote. Did I read that correctly?
You did.
So at this point, you were also considering scene integrity, fair?
Oh, yes,
And you were considering the avenues of possibly a faulty investigation or a less than thorough investigation. Is that fair?
sure.
Which is things that you brought up at trial, actually, right?
Yes,
And again, continuing on there, Mr. Sabers came on the case before you, correct?
yes,
And at that next sentence, he says to you, quote, "In my prior musings, I concluded that eventually finding faults with the shortcomings of their investigation would eventually be the route to follow, as opposed to hiring someone else to process the scene," right?
yes,
So when we talk about processing the scene, we're really talking about evaluating the scene for alternative theories or looking for additional evidence, right?
correct.
And so at this point, you and your co-counsel had considered this as a choice, right?
We did.
And so things like an accident reconstructionist, for instance, or an evaluation probably wouldn't have been on your mind as viable avenues for the defense.
It was not.
Now, you were asked about a biomechanical engineer specifically, weren't you?
Yes,
Oh, and I'm sorry, I do just want to talk about, there was one more sentence that I figured I'd go ahead and cover with State's Exhibit G. The last sentence of Mr. Sabers' reply to you reads, quote, "That mark on Amy's chin looks like she went down onto something like the auger," close quote. Did I read that correctly?
You did.
So you knew about a potential avenue of whether or not the auger was involved in causing Amy's injuries.
Yes.
And you also knew or were considering whether or not the fall to, or the mark on Amy's chin was due to a fall injury, right?
Yes.
But it's fair to say, like before, you didn't believe that a fall was a viable avenue or claim, right?
That's correct.
And that's with more than 4 decades worth of experience predominantly focused in criminal defense, right?
Yes.
So again, returning to the discussion of a biomechanical engineer, have you ever worked with a biomechanical engineer?
I don't think I ever did with someone that had that exact title, no.
And so, have you ever heard of a case in the state of Iowa, where a criminal case in the state of Iowa, where a biomedical or biomechanical engineer would provide testimony?
Sure, I read all the appellate decisions and belong to IAJ where we trade information like that.
So being aware of their work and the type of work that a biomechanical or biomedical engineer would do, you knew of that, right?
Sure.
And based on your experience and judgment, you did not believe that it was a viable avenue to do a scene reconstruction, for instance, here, right?
I did not. That's correct.
But looking to State's Exhibit H now, you and your co-counsel, again, were considering potential expert testimony in this case, right?
Yes.
In fact, you considered having the medical evidence reviewed by maybe an independent medical examiner or an expert witness in your case, right?
Yes.
Looking to what is the May 2nd, 2019 email message between you and your co-counsel, Mr. Sabers, do you see the message with the title subject being R.E. Bond?
Yes.
That first paragraph says, quote, "We can and probably should have the autopsy report reviewed, regardless of our opinion that it was not an accident." Did I read that correctly?
You did.
So in this instance, you were also considering it from the perspective of whether an accident was potentially viable.
Yes.
And is it safe to say that that claim was coming from things Mr. Mullis had told you, as well as potentially his family or support system?
It was, yes.
But as your investigation progressed, the medical information didn't seem to be necessary for you to retain your own expert, correct?
That was our conclusion, yes.
Is it fair to say, based upon the number of times you discussed it, that you actually did contemplate or research reaching out to an expert?
Sure.
And that avenue was either not proceeded with or was otherwise fruitless, right?
That was the conclusion.
Early on in the case, though, as you mentioned, I believe, or at least in your prior notes, that a bond review or lowering Mr. Mullis's bond was a primary focus at the start of the case, right?
Correct.
You spent a significant amount of work on attempting to lower Mr. Mullis's bond, right?
Yes.
In fact, you even filed for an interlocutory review or an interlocutory appeal to have the Supreme Court attempt to allow you to lower his bond, right?
Yes.
And this was noted to be a significant concern for Mr. Mullis, wasn't it?
He was extremely stressed about being in jail.
In your interactions with Mr. Mullis, he regularly was stressed about either being in a jail setting or incarcerated or the case, right?
He was, yes.
In looking down to the next message on State's Exhibit H, which was from your co-counsel to you, sent or on May 1st, 2019, do you see that?
Yes.
In this message, based on your review, is it fair to say that Mr. Sabers or yourself had provided Mr. Mullis with the reports of law enforcement officers or investigators in this case?
I think Bob took those to him, yes.
And in fact, you and Mr. Sabers had expressed your questions or attempted to answer his questions too, right?
Yes.
But at this point in time, starting with the third sentence of that message, let me know if I read this correctly, Mr. Firehelm. Quote, "He told me that he doesn't want to read them because his anxiety goes through the ceiling when he reads things and he can't function." Did I read that correctly?
You did.
And again, in this message, is it fair to say that you were aware of Mr. Mullis's concerns or belief that this was possibly an accident, but that he wanted to rule it out at this point in time, right?
Yes.
And ultimately at the case, he didn't tell you not to proceed with conceding that this was a murder, right?
Objection. There's no foundation for that.
Overruled, the witness can answer if he's able.
I don't recall Todd ever ruling that out. Well, would you state your question again? I may have misstated.
Sure. So Mr. Mullis believed that this was an accident early on in the case, correct?
Correct.
And he held out to you that this was a possible accident at all times, fair?
Yep.
But by the time of trial came around, Mr. Mullis himself even testified that this was a murder case, wasn't it?
I believe he did.
And so, in that point in time, prior to trial, you had prepared Mr. Mullis for taking the stand, correct?
Yes.
You intended to engage in a review of the evidence to allow him to tell his side of the story, fair?
Yes.
And at that point in time, on cross-examination, on the last day of trial, Mr. Mullis, in fact, conceded that this was a murder, fair?
I'm going to object. I think the transcript would speak for itself, and the transcript is in the record. I believe that what counsel's referring to is cross-examination, and he's misleading or mischaracterizing the testimony of Mr. Mullis and the questions that were being asked of him regarding the evidence presented at trial and whether Mr. Mullis agreed that evidence was presented that it was a homicide versus an accident.
Well, certainly I'll have the opportunity to review the entire transcript and this section in particular. Mischaracterizing that testimony certainly isn't going to be helpful if that's what's happening. So the objection is overruled. Do you remember the question, Mr. Firehelm?
No, Your Honor.
All right. I'll have Kelly read it back since there was an objection, but you'll need a microphone, Kelly, if you want to use mine.
And at that point in time, on cross-examination, on the last day of trial, Mr. Mullis in fact conceded that this was a murder. Fair?
I believe that's correct.
Your Honor, to clear up something, may I go ahead and present? Mr. Firehelm, I'd like to show you what's previously been indicated as Volume 5 of the trial transcript and what's previously been admitted into evidence as Exhibit 351, I believe. Directing your attention to page 56, beginning at line 12, the prosecutor asked Mr. Mullis, and somebody came onto your property right under your nose and killed her being Amy, right? That's what you're told? To which Mr. Mullis responded, that's what I'm told, right?
Yes.
And then the state asked Mr. Mullis, quote, and you know that's true now because you heard all the testimony in this case, right? To which Mr. Mullis said, yes. Did I read that correctly?
You did.
And the prosecutor next asked Mr. Mullis, you know that somebody took that corn rake and stabbed Amy in the back 2 or 3 times? To which Mr. Mullis said, yes. Did I read that correctly?
You did.
You now know this wasn't an accident. To which Mr. Mullis said, yes. Did I read that correctly?
Yes.
So we knew where we were at trial, as did Mr. Mullis based upon his testimony. Is that a fair understanding?
I believe it is.
And again, this is from if you know, this is from Mr. Mullis' sworn testimony while under oath, correct?
I believe it is.
Now, speaking of preparation for testimony, you believed Tristan Mullis' testimony was essential to this case, didn't you?
I did.
Is it fair to say that you understood Tristan to be an alibi for Mr. Mullis?
I did.
But shortly before trial, there was some break in Tristan Mullis' statements regarding how long Mr. Mullis was out of his sight, right?
That's correct.
Tell me a little bit about that. What was the concern?
We deposed Tristan at Al Parrish's law office. I believe Todd, I don't know if it was video or just audio, but he was listening in. And Tristan gave his testimony as to being in the barn with his mother and father, or his mother leaving, and staying there, helping his dad, helping Todd clean things up and make repairs and such. He testified that he went into the kind of a work area at the front of the building, I believe to get a drink of water, and then went back in the building, the main part where the hogs would be, where he saw his dad again. And he gave an estimate of how long he would have not been able to see his dad. And it was quite short. I can't remember, 30 seconds or something, long enough to get a drink of water.
Now, is it fair to say your understanding was that Tristan's testimony stated that Mr. Mullis could not have could not have murdered Amy Mullis because he wasn't out of Tristan Mullis' sight long enough to be able to commit the crime?
That's basically it, yes.
During the course of your investigation and prior to trial, however, Tristan Mullis' testimony changed, didn't it?
Yes.
In fact, at his deposition, where he was represented by his own counsel, Tristan Mullis' testimony, for the first time while he was under oath, changed to say he couldn't recall a specific amount of time, right?
I believe so.
And that's ultimately the same sort of statement that he made at trial, if you remember, right?
I think so, yes.
Where he was also under oath, fair?
Yes.
Was this shocking to you when this occurred?
Yes. In some ways.
Because I believe, as you stated earlier, Tristan's testimony was critical in this case, yes?
Yes.
But you worked hard in order to try and convey that Tristan Mullis was still with his dad for the bulk of the time in that hog barn on the day Amy Mullis was murdered, right?
Yes, that was critical.
You asked him questions specifically about possibly the number of times that he would have gotten a drink of water or been out of the sight of his dad, right?
Yes.
You asked him about family dynamics between Mr. Mullis and Amy Mullis, didn't you?
I think so, yes.
And I believe you, correct me if I'm wrong, but was the goal to convey that Mr. Mullis and Amy Mullis were in a loving marriage and that they were a happy family?
Yes.
And you made that effort to convey this central theme with each of the state's witnesses who would potentially say something different, right?
I think so, yes.
And if you recall, during some of the witness testimony, you asked about showing they worked on their marriage through marriage counseling, for instance, right?
Yes.
That they took trips together to places like potentially the water park, fair?
Yes.
And that they were working on their marriage and being supportive. True?
True.
And I believe during your cross-examination, perhaps of Ms. Stainer, you mentioned the messages that specifically related to Amy Mullis calling Todd Mullis super dad or something to that extent, right?
Correct.
So at all times, you were working to convey not only a happy family approach, but also an approach that Mr. Mullis was a loving husband and father, right?
Yes.
And at least by the end of trial, you had even worked on reviewing those messages to keep instances of potential violence or prejudicial acts like was present potentially in Ms. Stainer's messages, for instance, out of the jury's view. True?
Yes.
And that's because you not only believed your client was innocent, but you were working to convey, a solid narrative of a united family. Is that fair?
Fair, yes.
Looking to the trial, when Mr. Mullis took the stand, do you recall asking him about the hunter safety course that his daughter was a part of?
I think we did, yes.
And directing your attention to what I believe is trial transcript volume 4, which has been previously admitted as exhibit 350 in this case. And directing your attention to what is page 170. In scrolling down to the second half of the page, I believe, one moment. Looking at line 10 to line 14, you asked Mr. Mullis specifically if he had Googled about cheating wives or cheating spouses, didn't you?
I did.
And he denied it on the stand, didn't he?
Yes, he did.
And similarly, going down to the next two lines, Mr. Mullis denied knowing who would have looked that up, didn't he?
He did.
looking down to the second half, beginning, I believe, at line 22 to 24, you also asked him about potential TV shows or channels that they would have watched as a family, right?
I did.
And potentially, you also asked him, going on from line 25 to the next page, about whether or not those searches could be follow-up searches on those shows, right?
That's correct.
Similarly, you evaluated or considered how they enjoyed history and of the Native Americans or Indian populations, right?
Yes.
And that there was evidence that they would watch not only shows about this, but potentially searches would align with these topics. Fair?
Fair.
Now, scrolling to what is page 174, beginning at line 14, you also asked Mr. Mullis to explain potentially some of the searches that related to starving to death, drowning, floating, those kinds of things, right?
I did.
And you allowed, or Mr. Mullis had the opportunity to say under oath that those topics were more normal or, when considered in context, were not indicative that he committed a murder, right?
That's correct.
You also, looking to line 22 of page 174 of the transcript, you asked about chest wounds, gaping chest wounds, surviving the cold, and other survival tactics or habits, didn't you?
I did.
To which Mr. Mullis answered, as we see mostly on page 175, that she was engaging in a hunter education program, an online thing, and that she was studying for it, and him and Amy Mullis were helping her review those educational course materials, right?
Yes.
And by her, I mean your daughter specifically, in this case. I'm sorry, Mr. Mullis' daughter specifically. We're late in the day, obviously.
Correct.
So you also asked about the hunter safety course materials specifically that have been, relevant not to, just to this proceeding, but what was the underlying Google searches too, right?
Yes.
In fact, when you crossed Deputy Himaseth, I believe, then Deputy Himaseth, on the Google searches specifically, you asked him to review things from K Jewelers and other things like Pinterest, for instance, too, didn't you?
I did.
And in your closing arguments, you mentioned specifically that these things suggested the iPad in question or the Google account itself were not just used by Mr. Mullis. Is that fair?
Yes, it is.
So you sought, is it fair to say, to categorize your work in this case that you attempted at every turn to mitigate the Google searches and the state's narrative of what they represented?
That's correct.
Taking you back again to a pretrial evaluation and how it impacted your trial tactics. You were asked on direct examination about whether or not you were looking for witnesses to testify to Mr. Mullis's good character. Do you recall that?
Yes.
But you were actively in contact with his family, weren't you?
Yes.
And individuals like Tom Krogman, for instance, who were mentioned, were also interviewed by DCI as well, weren't they?
Yes, they were.
And in those reports that you received and provided, in fact, to Mr. Mullis, you would have considered his role in the case. Is that fair?
Yes.
And that would be both as a potential person to help you investigate the case and as a potential person to testify on Mr. Mullis's behalf, right?
Yes.
But ultimately, as a matter of trial strategy, you chose not to call Mr. Krogman. Fair?
That's correct.
For that question, I think it's improper to ask if it's a matter of strategy when the witness hasn't testified that there was strategy in not calling Mr. Krogman.
Overruled. The answer will remain in the record.
So knowing how things impacted the case as it proceeded to trial two, you were asked several questions about the 911 call. Do you recall that?
Yes.
Now, in all cases, you actually listened to the 911 call before trial, didn't you?
I did.
And it was a part of your overall investigation and discovery into this case. Fair?
Yes.
Did you also speak with Mr. Mullis about the 911 call and what happened prior to Amy Mullis, leading up to Amy Mullis's death?
I'm sure we discussed it, yes.
And to your understanding, is it fair to say Mr. Mullis conveyed to you that he didn't see how Amy Mullis died?
He said he didn't see how she was injured.
But he did tell you that he had pulled the corn rake out of Amy Mullis's back in order to be able to transport her to the hospital.
Can we get objection to foundation? When did Mr. Mullis say that to Mr. Firehome? What's the underlying context?
Mr. Duden, would you like to lay some additional foundation?
Sure. Early in the case, did you ask Mr. Mullis what happened leading up to Amy Mullis's death?
Absolutely.
Would that be prior to you determining what course of action or case theory you wanted to proceed with to trial?
Yes.
Would that be early on, say even before the trial information likely was filed in this case?
Probably so, yes.
So it was an early, is it fair to say that it was an early topic of discussion between you and Mr. Mullis?
Yes.
Hi, Teresa. I'm back from our math
Having
class.
listened to
I'm back from our math class. How are you? Kiddo did good. She always does good on math, though. You know, I mean, she always does really good. Front and back. So cute. So cute. Ay. You forgot your backpack for math class, Margaret. Were your shoes on the right feet, ma'am? Oh my goodness. What do you guys think of this defense attorney, the one on the Zoom call? What do you think of him? Todd's previous attorney. Do you think he did a good job defending Todd Mullis, or do you think he did not do a good job defending Todd Mullis? I would love to hear your thoughts.
The 911 call, that call ultimately came into evidence, correct?
It did.
And prior to Mr. Mullis's cross-examination, you had no reason to believe that the state would argue that the muttered statements under his breath that were claimed to be there were present, did you?
Had no idea.
But in response to those statements being alleged by the state, in your closing argument, you attempted to undermine the value or the claim that the statements about Amy Mullis.
Michelle is not budging from that guilty. Guilty. She said, I think he knew Todd was guilty. Probably.
Being a cheating whore or telling her to, quote, die cheating whore was on the record. Is that fair?
Yes.
Oh, I believe it was, quote, go to hell cheating whore. I apologize for that statement. In those statements, you believe that there was heavy breathing, yes?
Yes.
In that you believed he was working to
Heavy
revive
breathing.
his wife. Is that a fair assessment?
Yes.
Your arguments at each time said that the state's asserted claims were false. Is that right?
That's correct.
Now, primarily as it relates to the heavy breathing, you were shown a potential transcript of a 911 call. Do you recall that?
Yes.
And in that transcript, when you read, do you recall reading from it?
When it was shown to me yesterday, yes.
And if you remember, in that transcript, they indicate there's things like heavy breathing, right?
It did.
So in fact, your claims or your arguments presented at closing were fairly consistent. Is that right?
I believe they were.
But is it your opinion that that ultimately came down to a weight or credibility determination for the jury?
I believe so.
And ultimately, after the trial came back and the jury found Mr. Mullis guilty of murdering Amy Mullis, you moved for a new trial and judgment, or to arrest judgment. Do you remember that?
Yes.
And you alleged that it was misconduct, in fact, to claim that those statements were made on the 911 call. Fair?
I believe it did, yes.
And so you sought to preserve that claim and also to ensure that Mr. Mullis had the fairest trial he could have, in your opinion, right?
Correct.
Now, in your more than 40 years of experience as a criminal defense attorney mostly, have you had transcripts of 911 calls be completed?
Certainly.
Have you done that yourself?
Yes.
Did you believe it to be necessary in this case?
No.
And to be fair, your arguments were to what was being said under someone's breath rather than overtly in the statements heard on the call. Is that a fair assessment?
Yes. It's my understanding that, and this was told to me by the prosecutor, that this muttering under and saying those terms was called in by someone watching on court TV, and that's how it came about.
So you weren't really assigning a lot of weight to these claims, is that fair?
That's very fair.
Did you ultimately review the Court of Appeals decision in this case?
I did.
And to your knowledge, did that opinion or ruling speak to the potential substance of the 911 call?
I think there was a footnote to that, about that, yes.
And if you recall, or correct me if I'm wrong, do you believe that that went, like you believed as well, to weight rather than a matter of fact, for instance?
Yes, I agree with that.
And that ultimately is how you proceeded in this case, right? You argued it in closing rather than sought to omit it from its admissible use.
Yes, that's correct.
And you attacked its use even after the trial.
Yes.
Correct me if I'm wrong, too. At the time that then Deputy Himiseth took the stand at trial, you even asked him about UTC time, too, didn't you?
I did.
And in that line of questioning, you talked about cell phone extractions and the specific information at hand to the electronic devices like the iPad, right?
Correct.
And your course of action, is it fair to say that it was a strategic decision to proceed with attacking his credibility when you, so that you could argue what he said didn't make sense?
Exactly.
And that is what you actually did in closing, too, right?
Yes.
Mr. Firehelm, you've reviewed digital forensics information before, right?
I have.
You reviewed electronic discovery before, too, right?
Yes.
And that would include even evidence from a Cellbrite phone dump. Yes?
Many times.
So you knew how to look at the records and electronic information provided to you as a part of the investigative file from the state shared during discovery, right?
I believe so.
And you talked through that discovery and those investigative files with Mr. Mullis, didn't you?
We did.
I don't think there's been any foundation that a conversation was ever held with Mr. Mullis regarding whatever piece of electronic evidence the state is trying to ask about.
Well, certainly there was testimony that counsel reviewed discovery materials with Mr. Mullis. Objection.
Did he answer? During those periods of time, do you recall Mr. Mullis ever mentioning planting being an evaluation during, as to why he wouldn't have been able to make those searches?
That he was planting crops?
Yes.
Is that what you mean? Yeah, he talked about his schedule of long hours and working into the night.
But he never proffered it as a reason for why he didn't use the iPad, right?
Right.
And you didn't view it from the claim that that would have made it so he couldn't access the internet, true?
Correct. Right.
And in fact, when you asked him about it at trial, when he was on the stand, planting was not a reason that was provided as to why he couldn't have made those searches, right?
I think that's correct.
But still, he denied that he even conducted those searches, fair?
Yes.
So at no point in time did Mr. Mullis, to the best of your recollection, did Mr. Mullis or his family ever provide that as a proffered reason why he could not have done the Google searches, fair?
I think that's fair, yes.
Looking to what's previously been admitted as Exhibit 233, which I know has been the subject of communication previously. Hold, please, I apologize. One moment while we get that pulled up for you, Mr. Firehelm. Do you see Exhibit 233 on the screen, Mr. Firehelm?
I do.
Now, going to that last paragraph, I believe you had testified on direct examination that Mr. Mullis's inquiry about a possible quote-unquote expert, you believed it to be just shotgunning. Am I right?
Yes.
And if I understood your testimony correctly, and please correct me if I'm wrong, this was because you and Mr. Mullis had evaluated different kinds of defenses and different ways to proceed at trial well before the trial ever took place, true?
That's true.
And this included what witnesses to call, including any potential need for an expert witness possibly.
Yes, that's correct.
But looking at this page, if you don't mind scrolling to the top, thank you. On 233, do you see where it begins at number 18?
Yes,
So in this line, is it fair to say that this looks to be an incomplete list?
yes.
And this exhibit actually doesn't have a date on this note specifically, does it?
I don't see one.
Do you even know when this note would have been sent to you?
I would have no idea.
How, other than the notation of legal up top, would you know that this was meant for you?
That would be my guess, that if he wrote legal on there, that the jail would let him mail it or something. I don't know.
Well, knowing that, Mr. Firehelm, I'd like to scroll and draw your attention to what I believe is page 2 of this exhibit. Does this page have a date either?
I don't see one.
So like before, you don't know when you would have received it, if at all. Is that fair?
That's correct.
And you don't know when it would have been sent or what it would have been about. Is that fair too?
That's fair.
Now, if you want to go ahead and review a little bit of this text, Mr. Firehelm, specifically the first 3 sentences, I'd like to ask you about the context of what this letter shows for you.
Okay.
Now, when you're going through this message, do you note that there's various individuals and different witnesses that the state called at trial?
Yes.
In conversations about the inclusion of, say, porn or the testimony of someone being critical, this case being Tristan, was important for not only trial purposes, but also for your case, right?
Yes.
Is it fair to say that you cannot with certainty say that this case or this letter was not received or, an insight after trial, for instance?
It could have been. I mean, I can't tell from just looking at it.
In fair point. So there's no way to know when this would have even been sent to you, if it was sent to you at all, right?
That's correct.
Now moving to the next page of the same exhibit, what is page 3, I believe. Focus on the screen. The first word on that screen, if I'm reading it correctly, is Lynn, correct?
Yes.
Now, I don't mean to, play games here, Mr. Firehelm, but is your name Lynn in any case?
No.
Is this any indication that this letter was even sent to you?
Doesn't look like it was.
So it's fair to say that it was actually not even a letter to you at all about the case, right?
That's quite possible.
And going to the next page, page 4, and I don't mean to beat a dead horse with this or anything, but this one's also addressed to Lynn, right?
It is.
So much of this document, if we'd like to proceed to the next page, for instance, or some of the others, would suggest that, again, I believe Lynn is the name shown in the top corner with a date actually on this copy, right?
Yes.
And that date is August 29th of 2019, right?
Yes.
So this letter too was not addressed to you, right?
It appears not. Yes.
So looking back on it, these ideas and insights from Mr. Mullis were not likely provided to you. Is that a fair assessment?
I don't remember seeing these, no.
So much of these ideas are either unbound in time or you're not the addressed recipient or intended recipient of this. Is that fair?
It's fair.
But drawing your attention to the other evidence in this case, and I don't need this specifically anymore, you discussed the DVR cameras or the security cameras on the Mullis farm too, didn't you?
Yes.
And that was on direct examination. You discussed how potentially those cameras would have gone out, right?
Yes.
The foundation, direct examination of who?
Your direct examination,
Of Mr. Mullis?
Mr. Fire.
Oh, sorry. I will draw that, yes, okay.
And just for clarity of the record, during the direct examination of you, Mr. Firehelm, shortly before, you discussed those DVR security camera recordings, right?
Yes.
But that direct examination wasn't the first time you actually discussed those cameras, right?
Correct.
At trial, do you recall that you alleged, like Mr. Mullis had told you previously, that potentially the cat had knocked it off or interrupted the signal? Is that fair?
Todd told me that, and so did his brother Mike, and maybe even Lynn too. I don't know.
So you investigated that evidence, didn't you?
Yes.
And you took not only Mr. Mullis at his word, but the the support system that he had in place of his family too, right?
Yes, and then I went and looked at it, and Oh, maybe I shouldn't volunteer, I'm sorry.
Well, I'll go ahead and ask the next question. What is your insight on this issue specifically? What were you just going to say?
I grew up on a farm with dairy cattle and cats and corn rakes and so forth. I was proud of myself as an attorney when I walked into the courtroom and talked to jurors and argued cases to have that practical experience. And when I walked into the shed and looked at the window and how it was situated, cats like to lay in the sun. I think that window faced west in the winter part of the year. All these things make sense. So that's what I meant. I'm sorry.
And again, you believed in your client's innocence through the trial, didn't you?
Very much so.
And you argued till the end of your representation that Mr. Mullis was not the one who had murdered Amy Mullis, right?
I did. That's correct.
But you knew what evidence would be essential to your case, didn't you?
I did.
And that critical piece of evidence was going to be Tristan Mullis's ability to provide an alibi for Todd Mullis at the time, correct?
Yes.
So when he changed his story specifically, or when he was potentially not going to be available to testify, you brought that to the judge's attention, didn't you?
I did.
Drawing your attention to what's previously been marked and admitted as State's Exhibit I. Let me know when you have it in front of you, Mr. Firehelm.
I have it right here on my desk.
For clarity of the record, Judge Bitter was the judge who presided over the case at the criminal trial level, is that right?
That's correct.
And so this email is dated August 13th of 2019, correct?
Yes.
And so this lengthy email with representatives of the state as well as for Tristan Mullis and your team too were included on this message, correct?
Yes.
And in this message specifically, you inquired about whether or not waiting for Tristan's potential issues addressed with his counselor to be addressed sufficiently so that he could testify at trial, right?
Yes.
And in order to ensure that he testified at trial, you floated the idea of a continuance to Mr. Mullis, didn't you?
I did. Sorry.
And in speaking with him about this, Mr. Mullis was adamant that trial should proceed as scheduled, wasn't he?
Very much so.
And so he was opposed to continuing the trial date, and that was your position too, wasn't it?
He was opposed to it.
And at this time, trial was set for September, right?
Yes.
So in the interim between this email and when you began trial, you deposed Tristan Mullis, didn't you?
Yes.
And that was when his story changed, yes?
Yes.
But you proceeded to trial in September because Mr. Mullis did not wish to ask for a continuance, right?
That is correct.
So when we look at that September timeline, you were also asked potentially about whether or not he would have a fair jury that, at least my understanding would include potential farmers as well, correct?
That's how I understood it, yes.
But it was Mr. Mullis who wished for the case to proceed that month, right?
Yes.
In that month, I mean harvest season, true?
Yes.
And you were following the directions of your client, is that fair?
Yes.
So you proceeded to trial, but you had previously moved for a change of venue, right?
Yes.
Now, with about 40 years or more now of legal experience, is it fair to say that you know a judge would decide what venue to send it to rather than the parties specifically shopping for one?
Objection to the characterization of shopping in the state's question. It's inflammatory and prejudicial.
Would you like to revise your question, Mr. Duden?
Sure. Mr. Firehelm, in your experience as a lawyer with more than 40 years of practice under your belt, do attorneys get to choose what forum they go to when they move for a change of venue?
They don't have the final say, no.
Is it fair to say that a judge would make that ultimate decision?
No,
Correct.
Donnie.
And in
not
this
to
case,
my
the judge
knowledge.
decided to move the venue to Dubuque County, right?
Yes.
And at that time, the concerns were ultimately revolved around whether or not Delaware County and Dubuque County were in the same media market, true?
That was one of the concerns, yes.
But you had asked prospective jurors when selecting a jury about potential exposure to media and their biases, didn't you?
I did.
So you sought to address those concerns to ensure your client would get a fair jury or a fair shake, right?
Yes.
And ultimately, when the jury was selected, did you have concerns about there being a fair cross-section or whether or not more representation of farmers or anything like that were going to be dispositive in this case?
No, I thought that this panel during voir dire was one of the more cooperative ones that I had encountered in trials, and I felt the cross-section was pretty good, actually.
So, in your opinion, the selection of the jury was fairly good for the case that was at hand?
I did, yes.
And to your knowledge, at any point in time, was it conveyed to you that there was a concern about a lack of a fair jury or cross-section being selected?
I don't recall, once we got going and the jury was picked, no, I don't recall any concerns by Bob, me, or Todd.
So is it fair to say that it wasn't really a concern for you in the Mullis defense team?
I think that would be fair, yes.
You had spoken at length about Jerry Frazier while on direct examination in this case, correct?
I think so, yeah.
And specifically, at trial, were you pointing to Mr. Frazier as a potential person who would have motive to kill Amy Mullis as an option?
Yes.
You weren't necessarily saying that he was the murderer, were you?
No.
You were in fact pointing to many other people who could potentially have reason to commit the act, right?
Yes.
And again, at all times, you were maintaining the narrative that Mr. Mullis did not commit the act in question, yes?
Correct.
That he didn't murder his wife.
That's right.
Now, my understanding, Mr. Firehome, based upon your prior deposition testimony, is that, is it fair to say you view the role of a defense attorney as one to sow doubt or reasonable doubt into a case rather than to prove the alternate versions of a crime, right?
Exactly.
That the burden is the state's to prove that a crime was committed, in this case a murder, not your burden to disprove it.
That's correct.
And so, in this case specifically, you were looking to provide potential other avenues that would sow that doubt in this case or help you secure a not guilty verdict for Mr. Mullis, right?
That is correct.
Mr. Firehome, in your experience, would you say that you provided zealous advocacy for Mr. Mullis in this case?
Objection to the vagueness of zealous advocacy, and it's inappropriate to ask Mr. Firehome to judge his own performance.
Overruled.
Once again, I pride myself that, especially with the jury trials, that these situations for my clients are extremely stressful, important to them, in Todd's case, the most stressful, facing a life sentence. And I don't take that lightly, and I believe I did everything within the time frame that we had, that I did everything I could to obtain that verdict of acquittal.
I guess is one of the last things that we need to talk about. You, did you advise Mr. Mullis on his rights as it related to his ability to testify or not?
Yes.
Before trial, before he took the stand, did you work to talk through his testimony and help prepare?
Yes.
And in your professional opinion, or do you recall any instance specifically to which Mr. Mullis would have expressed concern or doubts about any of the process for him to take the stand?
I don't recall specifically. I mean, clients frequently say, you know, I don't want to blow it, I'm nervous, you know, those kinds of things. But I don't think Todd, you know, it wasn't like we had to drag him to the stand. And Frankly, I thought he did a wonderful job.
So just to confirm, you didn't encourage Todd Mullis to plead guilty.
Correct.
You didn't advise him that he should waive a jury trial.
No.
You didn't tell him not to testify on his own behalf or that he should, one way or the other, really, did you?
No.
You didn't force him to take the stand, right?
No.
And you never encouraged him to forego an appeal, did you?
No.
To that end, was the choice to plead not guilty and maintain his innocence all the way through trial, did you help Mr. Mullis maintain that objective through trial?
As best I could, yes.
In the arguments that were chosen to pursue, the argument specifically was to pursue believing that this was a murder, right?
Yes.
And as a brief recap, you reviewed the discovery yourself with Mr. Sabers and Mr. Mullis, didn't you?
A number of times.
You deposed witnesses in this case to ensure you understood the different theories of the state's case as well as possible theories for your case, right?
Correct.
You always believed that your client was innocent and held out to the jury that Mr. Mullis did not commit a murder did not murder Amy Mullis, right?
I did.
And you worked to address the pitfalls and concerns of Google searches or electronic evidence, didn't you?
I did.
And you sought to make sure he was prepared and ready to proceed in maintaining his innocence and helping prove his innocence when he took the stand, right?
Yes.
I don't have anything further, thank you.
Any redirect?
I do, Your Honor. Would it be possible to take a very short break just to get organized, and then I'll be ready to go?
Probably just a real short break. I imagine we're running short on time, so.
Thank you.
Okay, we'll take just a few minutes. Counsel, let me know as soon as you're ready. Mr. Firehelm, again, I'll go ahead and just leave the Zoom running.
Okay.
Okay. I know they have had a lot of breaks, right? Donnie? He just had a break. Why do you need another one? Okay, here we go.
Ms. Nichols-Cook, are you ready to pick back up?
Yes, thank you, Your
All
Honor.
right, may proceed when you're ready.
Mr. Firehelm, you were asked on cross about an email that indicated Todd was stressed and having trouble reviewing discovery. Do you recall that?
I do.
To your knowledge, had Mr. Mullis ever been incarcerated before?
Side note, I
And
really like
to
her
your knowledge,
glasses.
was this the first time that Mr. Mullis was learning about Amy's affair with Jerry Frazier in the discovery?
I'm not certain that's true.
Did you do any investigation to figure out if that was true?
We talked about it, but what I'm being careful here is I'm not certain that Todd told us that he knew about it before this discovery material was reviewed or not.
Would you agree, though, it'd be upsetting?
Certainly,
Yeah.
certainly.
I want to reference States Exhibit F, the email from April. I think you have that.
I do.
And in that email, it says, we need to have an expert take a look at the autopsy. Is that what it means?
That's what it says, yes.
But you never did do that.
No.
Do you recall a note that was passed to you after your opening statement that said WTF on it?
I eventually saw it. I'm not sure when.
Did you understand that to mean that your client didn't know what you were going to say in opening?
I'm not sure what was intended.
Did you talk to your client about it?
No, I don't think so.
And you would agree with me that Mr. Mullis never told you he believed it was a murder?
I'm not going to say he said those words, no.
You talked on cross about it was the state's burden to prove beyond a reasonable doubt that a crime had occurred. Do you remember that?
Yes,
And would you agree that in your opening you conceded a crime occurred?
yes,
And would you agree that Todd always maintained it was an accident?
he always maintained that that was possible, yes.
And in your deposition, you testified that Todd never agreed with you that it was murder. Do you remember that?
I think that's what I said, yes.
You testified on cross that Tristan, you considered him to be an essential witness because he was an alibi. Do you remember that?
Yes,
Tristan's testimony was only essential if you believed Amy's death was the result of a homicide, right?
yes,
You were asked about the change in Tristan's testimony in his deposition. Do you remember that?
yes.
Did you do anything to present all of the prior statements Tristan had made before his dad was arrested that indicated he was with his dad the whole morning?
I think we did, yes.
You were asked about the Google searches and the electronic evidence. Do you recall that?
Yes,
And you've also told us that you prefer paper over electronic documents, right?
as far as maintaining the files and exhibits and discovery, yes.
And I've showed you several things today that come from electronic discovery that you didn't have before.
Yes,
I want to go briefly back to Exhibit 233 that the state showed you and asked you about as well. Do you recall testifying in your deposition that this was Todd's handwriting and a letter you received from him?
no, I don't recall those specifics, no.
Let me find the page for you here. Elena, you put it in the Okay, Mr. Firehelm, you have a copy of your deposition in front of you, right?
I do.
And for the record, it's our Exhibit 323. If you could look at page 19 and start at line 22. And read through page 20, lines 8 through 13.
Read to how far?
Page 20, lines 8 through 13.
Okay, I've done.
And does that discuss letters from Todd?
Yes,
If you would go back to looking at 233, and we'll scroll to the third page. Do you see a date there at the top? I'm sorry, it's not the third page, it is the fifth page. My apologies.
yes, I see that date, August 29th.
2019.
Yes, correct.
This would have been about a month before Mr. Mullis's trial.
About 3 weeks, yeah.
And you testified earlier that you spoke with Todd's sister Lynn a lot during your representation of Todd,
Yeah, quite a bit, yes.
and that Lynn would give you information as well,
Yeah,
and that she would call you or email you and say Todd needed to see you or talk to you.
that was common, yes.
If you go down to page 10 of 233, Do you see the handwriting in the middle of the page at an angle?
Yes.
What does it say?
Lawyers first,
Hey,
then Lynn or Mike.
Chris. Only being Chris. I've missed you, girl. Hey, friend. Oh my God. 6 months. Love ya. When's coffee? Coffee, coffee, coffee. Coffee, 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 coffee. Yeah, I'll have to give you a call this evening or this afternoon. Will that work for you, ma'am? I hope you're doing good. Hope you're doing good. Hope you've been doing good. I've been a train wreck for a while, not even gonna lie. Me and kiddos' health has been like meow. But we're on the upswing now, Chris. On the upswing, I hope.
So is it entirely possible that this letter was sent
I'm obsessed with her glasses.
to you?
Object to speculation.
Overrule, the witness can answer if he's able.
Thanks, friend. Thanks.
Anything's possible, but I just don't think so.
But you were representing Mr. Mullis August 19th, 2019. So you would have been one of those lawyers referenced on page 10.
I assume so, yeah.
Do you remember signing an affidavit regarding your representation in this case?
Yeah, I remember signing one, yes.
It's Exhibit 224. We can show it to you. I don't know if you have it.
I think I have it.
Can you see the one on the screen?
Yeah, I just found it. I have it in front of me.
Okay. You were asked about the 911 call that was played for Todd on his cross-examination.
Yes.
And in this affidavit, can you read paragraph number 10?
Objection.
I did not.
Facts not in evidence, Your Honor. This is not an admitted exhibit, and consistent with the court's order on day one, affidavits have not and likely would not be admitted.
Your Honor, I was asking the witness to read it to himself. I apologize. That wasn't clear.
Okay, so for now, at least, the objection will be overruled.
Let me know when you've had a chance to read paragraph 10.
I have.
And do you recall me asking you earlier about
They are cute, right, Chris? Chris says, oh, her glasses are super cool. I think so, too. They're like big, chunky leopard print, you know? And by the way, I forgot. Thank you. I read your membership milestone here, but 6 months. Look at that. And then here, hold on. I got to give you some sparkle, ma'am. Got to give you some sparkle. Here we go. We haven't had any sparkle yet today. And I added this GIF, I don't know, a month or two ago, you guys. I can't remember. My favorite one. I like to throw this one in every once in a while. Just because that's the kind of attitude I've had lately, so. Yay. I'm glad. I'm glad. All right, we'll get back to it. But yeah, I want her glasses. Maybe she'll set them down on her table and I can sneak in and just snatch them. I don't remember what movie that was either, Chris, but yeah, it's a clip from a movie. I just can't remember which one. And it's been quite a while too.
whether you asked for move for a mistrial after that 911 call and the arguments were made by the prosecutor?
Yeah, I think you did.
And With all of the decades of experience, have you moved for a mistrial before?
Yes.
And do you agree that you could have and should have in this case?
In hindsight, I could have.
And in fact, you've said before you should have.
Right.
You were asked about conducting depositions leading up to this trial. Do you remember that on cross?
Yes.
You testified earlier that you didn't conduct any research or investigation before those depositions. Is that still true?
Research as to what?
Well, to prepare for depositions regarding the electronic evidence or any other topic?
I reviewed the discovery that had been produced.
Other than reading police reports, you didn't do anything else. Is that correct?
Talked to Todd, talked to Bob, Lynn, Mike, those kinds of things.
And you didn't consult any experts to help you understand the evidence?
Objection
That is
to the answer within the scope of the direct and the cross, Your Honor.
Overruled. If there is an answer, it will remain in the record. Okay.
So, this gal is giving him a run for his money right now, and he's feeling rather, I don't know, embarrassed maybe, irritated, aggravated. I don't know, all of the above, but the fact that he didn't, like, look into any experts at all is enough for me. It's enough for me. Enough. Sorry, chapstick time. You okay down there, Pop? She's laying down here on the floor and just being all kinds of lollygaggy. Yeah, Michelle, right. I would imagine he's tired of being questioned by a younger female attorney. He probably is, but at the same time, he's probably like, God, of course they're asking me all the questions that's going to make me look like I didn't do my job appropriately. The expert thing, that's, your dog threw up all over the guest bed. Ugh. Well, at least it was on the guest bed and not your bed. That would have, at least there's that. I know you still got to clean it up, though. I'm sorry.
I don't think there was. Mr. Firehound, do you remember the question?
I started to say it. My answer was that's correct.
You were asked on cross about complying with Todd Mullis's wish to not continue his trial. Do you remember that?
Yes.
Do you disagree that you didn't comply with anything else that Todd asked you to do as far as consulting an expert regarding whether her injuries were the result of an accident?
Objection argumentative in this state's testimony.
Overruled.
I don't do. My response to Todd's references to getting experts as ignoring him, or whether I complied with him. I think I've explained that before, how I viewed that.
You were asked several questions on cross about investigating issues. Are there actions you took that we have not discussed today?
The only thing I can think of is in some cases, as a member of the Iowa Association for Justice, in the criminal group of that organization, we have a pretty active listserv. So once in a while, an issue will come up, and rarely will the attorneys, and I'm one of them, will we give the name of a case or a client's name or something. But if it's an evidentiary issue or something like that, I think I probably did that in this case. I don't remember specifics, but that's one thing other than what we've talked about, I guess.
Thank you. I wanted to follow up on the testimony by Deputy Himsath at trial about the timing of those Google searches. Do you recall that?
Yeah, kind of.
Do you know why you didn't impeach him? That he had the calculations of the timing of those messages wrong?
I guess I thought we did to some extent. I don't remember exactly how the record reads.
Do you understand how to do a UTC calculation?
Yeah.
So if you didn't impeach him, you don't have a reason for that?
I guess whatever I did, I'll just stand on the record.
You were asked on cross about the hunter safety certificates and guide and the questions you asked Todd Mullis. Do you remember that?
Yes.
Did you obtain a copy of that guide and compare it to the Google searches?
I don't believe so.
Did you talk with Todd's daughter or Tristan about what types of searches they might have done?
I don't think so.
Did you only put Todd on to explain that, to testify?
Yes.
You were asked about your email in April where you believed it was murder based on your review.
Yes.
And you were asked about working with an accident reconstructionist or a biomechanical engineer, I think?
Yes.
Have you worked with an accident reconstructionist before?
Yes.
But you did not do that in this case?
Yes. That's correct.
Do you recall being asked in your deposition whether you had the consent of Todd Mullis to concede it was a homicide prior to making your opening statement?
I don't recall specifically, no.
If we could go to your deposition, page 22, I think, or is that 23? Oh, line 23, page 22, line 23.
Yeah, I see that.
And your answer to that question about whether Todd consented was no. Not like I'm okay with that, no.
That's what it says.
So any testimony you gave today that you think Todd knew is different than your testimony from your deposition?
Well, if that's the way you interpret it, that's not what I meant. What I testified to today, I think, is that I felt that Todd had acquiesced in that concept.
So, Mr. Firehelm, did you understand Todd to always maintain that it was an accident that injured Amy?
I'd have to answer that yes. Yes, but, I guess.
But you did not present that theory or investigate that theory for him. Is that accurate?
Didn't present it. I'm not saying we didn't investigate it.
But did you talk to any experts about it?
Objection,
No.
Your Honor. This is asking answered and cumulative to the record at this point.
Objection is overruled. The answer will remain in the record.
Your Honor.
Oh, wait. Any redirect?
I'm sorry, Your Honor, I have one more question. May I go back?
You may.
Mr. Firehome, in your opening statement, you told the jury that Todd's prior statements to law enforcement were wrong. Do you remember that?
If that's what I said, yes.
And then you put your client on to testify in your defense without any corroboration.
Objection, Your Honor, from just clarification of the record purposes, I believe that's necessary to say your defense, I believe, should be clarified if possible to Mr. Mullis's defense.
Certainly, that's the way the court understood it.
Thank you, Your Honor.
Do you want me to repeat or rephrase the question?
Please.
If the transcripts show in your opening statement that you told the jury Todd was wrong when he talked to law enforcement, and then you put Todd on in the defense in chief and expected the jury to believe him, that was what you did?
What I told the jury is that Todd told law enforcement that she fell, that it was an accident. That's what he initially thought. He testified on cross-examination that it was a murder. So I'm not sure what you mean, I guess.
I'll move on and follow up on that, and I know I have to be done. Todd's testimony at trial is reflected in the transcripts, right?
Yes.
And so if the prosecutor asked him, based on what you've heard at this trial, do you now know it's murder? Would that be different than Todd's belief that it was murder versus an accident?
I can't say.
Okay, and Mr. Mullis wasn't qualified to review the autopsy report or do an accident reconstruction to have his own belief.
I'm sorry. What was your objection? I didn't hear it.
Well, one, this is irrelevant, and it's not facts in contest, so it's immaterial and far more prejudicial than probative because certainly no one is contesting that.
Well, I think we're getting a little far afield here. Sustained.
No further questions?
Any redirect?
Briefly, Your Honor, permission to share the screen?
You may.
Perfect. Drawing your attention to what has been marked previously as Exhibit 350, and specifically drawing your attention to page 75, line 25. Do you see that, Mr. Firehome?
350?
Yes.
So it says, I want to talk to you about some of the times that you're given. What's UTC mean on this printout? That was your question to Deputy Himmelsath, wasn't it?
Yes.
To which you responded Central Standard Time, right?
Yes.
And you just say, if the internet tells you you're wrong, would you disagree? And he said, can you ask that again? I guess I've never had the internet tell me I'm wrong, which I believe is a joke or also just maybe in jest. In either way, have you ever researched that UTC is the successor to Greenwich Meridian Time, GMT? To which he responded, okay, I've never searched that, no, right?
Yes.
Now continuing down through page 77, line 5, let me know when you've reviewed it or if you need it slowed down. Have you reviewed it, Mr. Firehome?
I see it.
And in this case, so you did actually impeach Deputy Himmelsath on UTC time specifically, right?
I thought I had.
And so the record would speak on that point. Would you agree?
Yes.
Did you author your affidavit that was referenced earlier?
Yes.
In the time, it was not authored with the benefit of having your file, right?
That's correct.
Nor when your deposition occurred did you have the benefit of your file. True?
That's correct.
Because you had given it to ensure that the successor attorneys representing Mr. Mullis could continue their representation in the underlying criminal case and on appeal, right?
That is correct.
Knowing now, with the benefit of the records and the transcripts before you, is your testimony today true and accurate to the best of your knowledge?
Yes.
I don't have anything further, Your Honor.
Anything further, Ms. Nichols-Cook?
Just, Mr. Firehelm, do you know if you've ever seen the cell phone extraction data from Tristan Mullis's phone?
I don't think so, no.
And then just for purposes of the record, do we need to identify if there's someone in the room with Mr. Firehelm or not?
We can. Mr. Firehelm, is there anyone in the room with you? I guess I'm not sure if you're in your office or elsewhere.
I got the door locked, and I've been here by myself all afternoon.
Thank you. I guess back to you, Mr. Duden. There was another question from your
None
side.
needed, Your
So.
Honor.
You're done?
Yes.
Okay. All right, Mr. Firehelm, it sounds like that should conclude your testimony. Thank you. I'll go ahead and end the Zoom at this time.
Thank you.
Sheesh. You know, he's thinking, God, why did I have to do this today?
Turn the screens to shut down here.
What a way to end the week.
Okay, it is just about exactly 4:30, so it looks like this will be our ending point for the day. We'll plan on picking back up at 9 a.m. on Monday. Council, if you'd like to stop back in chambers, obviously we can touch base about the schedule. Anything else we need to do on the record before we break for the weekend? Anything on behalf of the applicant? No? Anything on behalf of the state?
No, Your Honor.
All right, thank you. Have a nice weekend. I'll see you on Monday.
All right, so we got through that day pretty quickly. Hold on just a moment. Hold on just a moment. Bum bum chicka bow 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 bow. We can start day 6, which is today, and see how far we can get. Maybe go for, I don't know, a little longer, since it's only 2:35 Eastern. Does that sound all right with y'all? Exit out of that, move this over here. Okay, now this is today's. All right, Michelle says, yes, please. Okay. We'll go a little whiles and then we'll just try to play catch up through the week until this is over. Hopefully this is not got much longer to go. I hope. I don't know. And I don't know who. I don't have any idea who's on the stand today. Who's testifying? Who's doing what? I have no idea. I did see earlier there was a woman on the stand, but I don't know who she was. No idea. So. Okay. I'm telling you, his hairdo is literally something from the 1970s. He's going to have to do something with that hair. I cannot. He is entirely too young to have that hairstyle. Now, I know he's doing it for a reason. We can all see it. But cut it all off, son. I can't. It's not so much even the comb over as it is. I mean, his part starts way over here and then. I can't. it literally looks like something from the 70s. I can't. Mm-mm. Right, Michelle? I'm not shaming him for the whole balding thing. Men go bald, okay? All the time. But there's a way to come into the 2000s and 25 and not look like you're from 1972. Oh my God. Exactly, Rise of Phoenix. Hey, good to see you. Just shave it all off, man. Shave it all off. And be done. Michelle said, "Yep, both my sons are both in the 30s and chose to cut it close to the scalp to not look like this." I mean, it would look better if he burred it pretty close. I mean, he wouldn't have to he's still got a lot of hair on the sides and the back and stuff. Just cut it all super super duper 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 short. And I don't know. I don't know. You just spit your coffee out. The comb over is too much for me. And I'm not trying to hair shame. I mean, I have hair shamed on a few occasions. I'm not going to lie. But sometimes he can't help it, right? He can't help it. But guys that have this issue tend to cut it off pretty short so that it doesn't look like they're from the 1970s. Judge, go put your robe on and let's go. Wonder who she is. Did they have a daughter or just two boys? I don't know. Good heavens, come on, people. Okay, here we go. There we
Good
are.
morning, please be seated.
That deep part, though.
Good morning, everyone. All right, we'll go ahead and go on the record.
There you go, Cherie, right?
We had some brief discussion off the record
That's their
regarding the
daughter. Okay.
schedule. And I believe the plan this morning, Ms. Thompson, is to begin with Mr. Safrick, and I see that he is on Zoom. Are you able to hear me this morning, sir?
I can, Your Honor, yes.
All right, and we can hear you loud and clear.
Perfect.
Ms. Thompson, was there anything we needed to address before beginning with the witness?
I don't believe so, Your Honor.
Okay, let's see if I can find my camera, and I'll swear the witness in here. 1 second.
Oh, let me put it on. I'm going to put it on 1.25. That helps a lot to get through things a little quicker.
Screens to keep track of here. All right, good morning. If you'd raise your hand, sir, I'll swear you in. Do you swear the testimony you're about to give will be true and correct?
I do.
Okay, whenever you're ready, Ms. Thompson.
Thank you, Your Honor. And Mr. Safrick, are you able to hear me okay?
Yes. Hold on 1 second. Let me just turn this up a little bit. Okay.
Good morning, Mr. Safrick. Can you please introduce yourself to the court?
Sure. My name is Mark Safrick. I am the president of Forensic Behavioral Services.
And what do you do for a living as the president of that company?
I conduct complex assessments of death investigations, death cases for interested parties to help them understand what happened, how those events within the case unfolded, and possibly sometimes why they occurred.
Are you familiar with the term equivocal death evaluation, Mr. Safrick?
Yes.
Can you tell?
Recording in progress.
Can you tell the court, Mr. Safrick, what an equivocal death evaluation is?
Sure. An equivocal death evaluation is an investigation where the manner of death, not necessarily the cause of death, but the manner of death is in dispute or in question, or where there are several possible scenarios that could explain the death.
And I want to get back to that concept with you, Mr. Safrick, but for starters, did you work in law enforcement prior to starting your company?
I did.
And can you tell us in general terms what your law enforcement career consisted of?
Sure. I started in 1977 in California with a local law enforcement city police agency. I started in patrol. I worked about 3.5 years in patrol and then promoted into detectives, started in property crimes, and finished out my time there in violent crime investigation. Subsequent to that, I applied to the FBI. I got into the FBI in 1984. I served in various field offices. I served 23 years in the FBI, the last 12 plus years in the behavioral analysis unit.
In total, how long was your law enforcement career?
30 years.
And in total, how many of those years were with the FBI?
23.
And you mentioned that you worked with the behavioral analysis unit in the FBI. Can you tell me what you did in that unit?
Sure. So there were 3 units. We had a child crimes unit, we had a threat assessment terrorism unit, and we had an adult crimes unit. So I was assigned to the adult crimes unit. I was responsible for, it's a relatively small unit. We had 8 criminal behavioral analysts. I was responsible for the 6 western states of the country for all cases that came in from law enforcement agencies from those locations. Most of the cases that I worked on were homicide cases, multicide, so serial murder, mass murder, spree murder, sexual homicide cases, and serial sexual assaults, all related to adults.
Did part of your work in that unit involve analyzing crime scenes?
Essentially, everything, despite the services that we offered, everything within the unit requires a detailed analysis of the crime scene. In whatever case it is and whatever we're being asked to provide to the requesting law enforcement agency. So it all comes down to conducting a detailed analysis of the scene, the antecedent behavior, the behavior during the scene, evaluating forensic evidence, physical evidence, and integrating all of that information together to understand the totality of the events that are occurring both in sequence and in time.
You told us earlier about this concept of equivocal death evaluations. Did you perform those evaluations while you were with the FBI?
I did.
And did you have experience at the FBI investigating cases where investigators initially believed the case was a homicide, but the case turned out to be something else?
Yes.
Have you published in the area of death investigations?
Yes, I've published, I have a book on spree murders. for police investigations. I have numerous peer-reviewed international journal articles on various aspects of death analysis and investigation.
Have you trained law enforcement officers on the topic of death investigations?
Yes.
Can you tell us briefly about your experience training other officers on this subject?
So I regularly do presentations for law enforcement groups and other groups for forensic nurses, victim advocates. I've presented to judges, to prosecutors, to defense attorneys, homicide investigators, violent crime investigators around the U.S. and throughout the world. I would say, conservatively, I would say I've presented to over 20,000 law enforcement professionals.
Are you the member of any professional organizations?
Yes, there's a number of them that I have listed in my CV. American Academy of Forensic Sciences, the VDOC Society, it's a cold case society. Off the top of my head, I have them listed, I just don't recall them now.
In your consulting career since you left the FBI, what kinds of clients have you consulted for?
Well, since I left the FBI, most of the clients are, I would say, attorneys, civil attorneys. So the types of cases that I work on typically involve some type of violent crime. But I've done cases for prosecutors, for defense attorneys, and even for private parties. Sometimes family members will retain me to examine a case. And so yeah, prosecutors, defense attorneys, and then in civil cases, both the plaintiff and the defense.
Do you have clients for whom you've consulted where the client ended up not using the opinions that you provided to them?
Yes, that occurred both in the FBI when we consulted with law enforcement agencies and also civilly. You know, the cases that I've done in the nearly 18 years since I've been retired from the FBI, there will always be cases where the analysis doesn't line up with what the attorneys are looking for, and then they don't end up using me.
I want to come back to this topic of equivocal death evaluation and crime scene analysis. And for starters, Mr. Safrick, you are not a medical doctor, is that right?
That's correct.
In reaching your opinions about crime scene analysis and case investigation, do you rely on medical diagnoses that are reached by medical professionals in those cases?
I do.
And do you also rely on objective evidence that's gathered by law enforcement investigators and others related to a case?
Of course.
Mr. Safrick, are you here today to offer any opinions on whether any particular person related to the investigation into Ms. Mullis's death is telling the truth?
No.
Are you here today to offer any medical opinions?
No.
And the opinions that you're going to offer today, are those opinions that you hold to a reasonable degree of certainty?
They are.
You talked about this concept of equivocal death evaluation. How does an equivocal death evaluation differ from another type of homicide investigation?
So most of the cases that I've worked on, both in my FBI career and subsequently, typically involve a violent crime, oftentimes a homicide. So the advantage when you are working a case like that is that you know at the outset that the manner of death is homicide. So that's never in question. When you're working an equivocal death case, they actually are much more difficult to work because when you get the case, the manner of death is either in dispute or it's unknown. It could be undetermined, which is one of the 5 evaluations that you can have in the United States for manner of death. So the way that you approach an equivocal death is different than you would approach, say, a homicide case. Here, you have to look at all of the various attributes of the case in terms of what is consistent and what's inconsistent with a particular manner of death. Now, I would say that in most of the equivocal death cases that I have worked, when you look at the 4 manners of death, which would be natural, accident, suicide, and homicide, in most of
Oh, hey, Ruth. Glad to have you back. Glad that you're back, too. I missed you guys on Friday for sure. So, but we're back. We're back. Thanks for popping in.
the cases, you can eliminate usually 1 or 2 of the 4. So you're usually left with 2 manners of death that you have to consider. So it's a more complex type of investigation because you have to consider various avenues of consistency and inconsistency with the forensic evidence, the physical evidence, and the behavioral actions that have occurred at the scene and how all of those translate both sequentially and in a time order or temporally.
Mr. Safrick, did you conduct an equivocal death evaluation into Ms. Mullis's death?
I did.
And did you review evidence related to the investigation into her death as part of your evaluation?
Absolutely.
Can you tell us in general terms what you reviewed?
So, what is important in literally any type of investigation is the initial police investigation. So that would be any investigation they did, any evidence that was collected, any testing of that evidence. In a death case, it would be the autopsy protocol, photographs and diagrams from the scene, any interviews of witnesses, the assessment of the scene itself. That is all the critical information. Typically, in those types of investigations, what occurs weeks or months later oftentimes isn't really relevant to what I'm doing because I'm doing a crime scene analysis. So it's everything that's attendant to the initial scene, which is typically frozen by police on their arrival.
And I do want to start talking, I want to start by asking you some questions about the scene that you just referenced. Based on your evaluation that you conducted in this case, did you develop opinions about the scene of Ms. Mullis's death?
Yes.
And are you aware that in this case, prosecutors argued to the jury that the scene of Ms. Mullis's death was staged?
Yes, I'm aware of that.
All right. So when we talk about the concept of the scene in the Mullis investigation, what do you understand to be the scene of where she was injured?
Well, okay, so I would say more broadly, the scene is literally the entire farm area of the Mullis farm. If we're referring just to the injury location, that would be the shed that stands between the house and the hog barns.
Is it your understanding in this case that Ms. Mullis died at the hospital?
Yes.
And why do you consider the scene to be the shed and the Mullis farm in this case?
Well, okay, so I would say I would consider the Mullis farm, or at least certainly the area around the house and the shed and the workshop and the hog barns as the overall scene area, because there were witnesses and individuals in those locations. I would say that the shed is the location for Miss Mullis's passing, because there's physical evidence in the shed that suggests that. The interviews that were conducted, the information derived from those interviews indicates that, and the police investigation and their theory is that her death took place in the shed.
In your training,
which I think is accurate.
And when you're talking,
excuse me, her injury took place in the shed.
In your training and experience, what does it mean for a scene to be staged?
So staging a crime scene is an attempt by the offender of, say, the homicide, because that's typically where you see staged crime scenes, is in homicides. It's an attempt by the offender to misdirect the investigation. And the way that they misdirect the investigation is to introduce either spurious or fake evidence, remove evidence, or create contrived activities or behaviors that actually didn't occur. And the idea is that the purpose is that they're trying to create a new scene that has a new motive, because that's what they want law enforcement investigators to look at and draw their own conclusion that this is what is actually occurring as opposed to what actually occurred. And so they stage the scene. The reason that staging is, and recognition of staging at a crime scene is important, because strangers don't need to stage a crime scene. They don't have a relationship dynamic with either the victim or the scene or both. So when you see intentional staging, then it suggests that the offender has some relationship with the victim or the scene or both of those.
So how is it that law enforcement evaluate whether or not a scene is staged?
Well, that's the point. So the offender, he manipulates the scene, either the forensic evidence or the behavioral evidence or the physical evidence. They manipulate the scene to change it so that when law enforcement comes and looks at the scene, that they're trying to overwhelm what law enforcement's logical conclusion about the scene would be, to make them think it's actually something different. So a new type of case that has a different motive. The problem is that when you are staging a crime scene, all of this activity then is happening after the crime. So it's not occurring in the right sequence or the right time order. And so you get inconsistent forensics, you get inconsistent injuries, you may have blood spatter in a location that doesn't fit the crime. So there are a lot of red flags that are evident in staged crime scenes.
Did you see evidence in this case that the scene of Ms. Mullis's injuries was staged in some way?
No.
And can you explain how you reached that determination?
Well, I would say first off, when you stage a crime scene, the point is that you need law enforcement investigators to come to the scene and look at it. You've changed the scene. You've changed the victim. You've changed evidence. You've created something that is supposed to look different. But you need investigators to see it because you need for them to draw their own conclusions about the scene. Incorrect conclusions, but that's the whole point. So here you don't even have a scene. And that's the point. So there's no staging that's going on here because investigators, they only come to the shed at a later time.
So why was there no scene in this case?
I'm sorry?
I said, why is it that there was no scene in this case as you just mentioned?
Right. So there's no scene because, first of all, Amy Mullis is not deceased. And there's an attempt to render aid to her, both in the shed and then subsequently in the truck, and then subsequently at the roadside location where dispatch advises him to stop the truck and meet law enforcement. There's no scene. The victim is not there. Everything is, suggests that Mr. Mullis was attempting to render aid to his wife in getting her to the hospital. So there's no scene to analyze, not for staging anyway.
In your experience, is an aspect of scene staging sometimes that a person that is staging a scene will generate a situation where someone else will find the victim?
Yes, that's very common, and not even in staged scenes, but in other types of homicide cases where it's called, we refer to it as third-party discovery. So what they don't want is to discover the victim, because then it creates a problem for them because they're not at an arm's length distance. So oftentimes they will have somebody else discover the victim. That could be a neighbor, it could be a coworker, it could be a friend. That puts them at arm's length from both the scene and the victim, and essentially allows them to try to create an alibi.
Well, here you're aware that it was not Mr. Mullis that found Ms. Mullis, is that right?
Yes, I'm aware of that.
And
yes.
In your evaluation of this case, did the circumstances of this case fit the third-party discovery dynamic that you just described?
I would say no for two reasons. One, in every third-party discovery, in any case I've ever worked, or any case that I'm aware of from my time in the FBI's behavioral unit, or in my 18 years subsequent to that, I have never seen a third-party discovery where a parent sends a child to make the discovery. It's typically an adult contacting another adult, not a family member, but, as I said, neighbor, friend, coworker, somebody that's disconnected personally, in a sense, from the victim. So that's not my experience to have sent. I've never seen you send a minor child to find, the parent. Secondly, it doesn't really work here because there's nobody here at the Mullis farm. This farm is isolated. It's out in the country. There are no houses around it. There were no other people. So it doesn't make any sense to send, if you're trying to do third-party discovery, it doesn't make any sense to send your minor child to make the discovery. For one, there's nobody else around. And two, the time frame is literally minutes. So we're not talking about hours or days. We're just talking minutes. So it wouldn't serve any purpose in terms of distancing yourself from the scene to send your minor child.
Did you see evidence in this case that Tristan Mullis was interviewed by authorities, soon after the events that brought Ms. Mullis to the hospital?
Yes, he was interviewed within minutes after the event.
Did his availability for interviews influence your conclusion that there's not evidence of third-party staging here?
Yes, partially. It's one of the things that I would say is consistent with it. Because he's a minor, you have to have parental permission to interview a minor. And Todd gave permission immediately for Tristan to accompany law enforcement back to the house to show them and tell them what he saw, what he did, what he found. And so that's inconsistent, really, because if you're the offender, you don't want a third party to be making statements that might affect your credibility or whatever you've told law enforcement.
And did you see evidence in this case of Mr. Mullis interrupting or preventing law enforcement from interviewing Tristan without Mr. Mullis there?
Your Honor, I'm going to object to this line of questioning as improper expert opinion testimony because it's a comment on credibility not only of Todd Mullis but also of Tristan Mullis in this case. Credibility is a determination solely for the fact finder, and it is not subject to expert testimony under 570(2), 3, and 4, I believe.
Overruled.
I think I did not get an answer to that question, Your Honor. Is that correct?
I didn't hear an answer. You may.
No, yeah, I didn't. Can you just repeat the question? I'm sorry.
I'll have to have the reporter read it back since there was an objection, so we'll give her a chance to do that.
Thank you.
And did you see evidence in this case of Mr. Mullis interrupting or preventing law enforcement from interviewing Tristan without Mr. Mullis there?
No, there were two instances where law enforcement asked Mr. Mullis if they could interview Tristan. One of them was immediately after, from the roadside location, to accompany Tristan back to the house to explain the whole situation there. And then later on that day, they also asked him again, and he said, sure, go ahead.
Did that permission impact your conclusions here about the scene not being staged?
I think, as I said, I think it's one piece, right? Because clearly, if you don't know what someone's going to say, especially with a minor child, it would be very easy to say, I don't want you to talk to him, or I want him with me, for whatever reason. So I think it's a piece that lends itself to suggest that he didn't care what Tristan told law enforcement because it was going to be what Tristan's experience was that morning.
Did you see evidence in your equivocal death evaluation in this case that there was planning involved in some way in someone hypothetically causing Ms. Mullis's death?
Right. So, I don't see any staging in this case, and I don't see any planning. If the allegation is that it's staged, I think if it's planned, it would be very, very poorly planned for several reasons. One, the weapon is really a terrible weapon. Can it inflict fatal injuries? Yes. But is it a good weapon to use? No. If you're planning this, you don't want your children around. You don't want to be in a position where you literally would have to escape from your son to commit this. And also, you have two other minor children in the house, a 10-year-old and an 8-year-old. You have no control over them. You don't know where they're going to be, if they're going to come outside, if they're going to go to the shed. That they played in the shed. So it would be extremely risky. So to do that with your minor children would be, problematic. Farm accidents are very prevalent. So if you're going to plan this, if you've spent time to think about this, then there are lots of other ways that this could have occurred that didn't involve your minor children and didn't involve a very odd type of weapon, like a corn rake. And it would have given you the privacy to interact with Amy at another location, somewhere off the farm property. But I just didn't see any evidence of planning because I don't think there's no staging here. And if this is planned, it's extremely poorly planned.
Did the fact that Ms. Mullis passed away at the hospital in this case, is that a fact that you took into account in evaluating whether or not there was planning associated with her death?
Yes, because the idea in a staged crime scene, one, is that the victim is deceased because you're going to be manipulating the scene, manipulating the victim. So the victim has to be deceased because if they're not deceased, then there's a possibility they can move away, get help, render the aid to themselves. it becomes very problematic. So the fact that she's not deceased, again, in terms of planning, if this was the plan to kill her, then, that didn't succeed.
If Ms. Mullis was, if there was evidence in this case that Ms. Mullis was the person who suggested the family work in the barn the day of her injuries, would that contribute to your analysis of whether or not Ms. Mullis's death was planned in some way?
Yes, it affects it because because of her medical procedure, she had been unsteady, dizzy. She'd been resting at the house for several days. So it was, I believe, only on that morning when she informed Todd that she just couldn't sit in that house anymore and was going to come out and try to help in the barn. So again, how would you know this? You really wouldn't know it. So it goes against planning. Additionally, in terms of the planning, if you're trying to stage this, so then you have to know where the corn rake is, right? You have to be able to tell police, yeah, I saw the corn rake there yesterday. I was in the shed yesterday. I saw the corn rake. It was right here. So because it has to be, the scenario would have to make sense, right? You're trying to make it make sense to the police. So yes, you're going to tell the investigators, yes, the corn rake was in the shed. I saw it in the shed. This is where I saw it, right? But that's not what you have here. Instead, when they asked Todd where the corn rake was, he's like, I don't know. I hadn't seen it for 2 weeks. Last time I saw it weeks ago, I'd set it against the wall, but I don't know where it was. So that doesn't make any sense if you're trying to stage a crime scene, right? You're trying to make law enforcement believe that this is, an accident, right? That's what you're trying. So you need to have the corn rake there, to confirm that for them, but it's not. And I don't think Todd knew until that morning that Amy was planning on coming out to the hog barns.
Is the topic of victimology relevant to equivocal death evaluations?
Yes, victimology is relevant to any type of crime analysis because understanding the individual whose life is taken or who dies, is really important to understand their background, and what effect that has on risk level for them. So understanding that background, all aspects of that background from their various types of histories, it could be criminal or psychological or financial, their relationship dynamics with friends, coworkers, family members, all that information is important to understand, who is Amy Mullis and, what's that dynamic relationship between her, Todd, other people in her life.
Is that what that term victimology means, what you just described?
Yes, right. And it also, especially when you're talking about risk, you're trying to assess at what level of risk is she to become the victim of a violent crime. But on the flip side, you're also, that also informs the level of risk that an offender is willing to take to commit the crime. So if you have a very low risk victim, which I would say Amy is, not only because of her lifestyle, but simply because she lives in a very isolated location that's difficult to really find and get access to her. But also, sorry, lost my train of thought. Also because, the risk would be very high for an offender to access her there. So risk is a balance between the victim and the willingness for the offender to take on, more risk. And the more risk an offender is willing to take, then the more important it is for them to, commit whatever act they're, preparing to commit.
Well, in considering victimology and in considering risk, in general, in conducting these type of equivocal death evaluations, do you consider the concept of infidelity in making that analysis?
Sure, if that exists, if it's relevant. So there are lots of different components to victimology, and their relationship dynamics in her relationships would be important. So if it's uncovered that there's marital infidelity, certainly that would be important to understand.
Well, in conducting this equivocal death evaluation, did you consider the issue of infidelity in the Mullis marriage in reaching your conclusions?
Sure, absolutely.
And how did that fit into your analysis?
Well, so once I was aware of it, then I have to put it in context, right? So everything that's done in my type of analysis is always within context. It's always within the totality of the circumstances. It's never a single piece of evidence that, is pulled out and assigned a value. It only has meaning within the context of everything you're looking at. So when I became aware that she had this affair with Mr. Frazier, then I wanted to take that into consideration. What do I know about that? Who knows about that? Did Todd know about that? What's that dynamic? What is that dynamic like? So, of course, it's a very important piece.
And did you draw any conclusions about how, if at all, infidelity would have played a role in the victimology in this case?
So one thing I really wanted to understand is, was Todd aware of it? Now, clearly there had been a past infidelity that he was aware of. But in this current one, based on the emails and the texts between Amy, Jerry Frazier, Mr. Frazier's wife, several of her friends whom she confided this infidelity to, there's nothing that I was able to see that led me to believe that Todd was aware of the infidelity. I mean, Amy said he wasn't. Jerry said he wasn't. In fact, there was questioning by Todd in, I believe it was July of 2018, where he had seen a number of texts between Amy and Jerry, and asked Jerry about them, or I think he asked Jerry about them, and was given what appeared to be a reasonable explanation for it, and then spoke to Amy, and to the extent that I think he felt badly that he had thought there could be something going on, and actually apologized to Jerry and to Jerry's wife. And in texts between Jerry and Amy, they were very confident that Todd was not aware of the affair.
In considering the issue of victimology, in assessing risk factors as you've described, do you as an investigator think through the dynamic of someone reporting events differently to different people?
Sure, absolutely.
And did you consider that dynamic in this case?
Of course.
And what, if any, go ahead. Go ahead, Mr. Safrick.
Well, so certainly, I mean, all of us have different relationship dynamics with people. We have our public lives, we have our private lives, and, some people have a secret life. But it depends on the relationship dynamic with your friends. So some of your friends are more distant. They're almost more like acquaintances. And other friends are people you see all the time. And then other friends are like really close friends. That could be the same for coworkers. So when the stories and the conversations that you have with different people in your life basically reflect the level of comfort you have with them, what you will tell them. And so you see, I mean, when you look at the conversations that she has with several of her friends and with Jerry, you can see the difference in the conversations, and that I think would be expected.
Do you need power? Yeah. There's a power socket in front of you.
Yeah, and I had him check it. I did get an answer to the last question, right? I don't need it read back. I just want to make sure. Okay, thank you. Did you see evidence in your evaluation, Mr. Safrick, that there were communications between Ms. Mullis and Jerry Frazier where Ms. Mullis was critical of Todd Mullis?
Yes.
And what, if any, conclusions did you draw from those communications in terms of Ms. Mullis's victimology?
I didn't think that there was anything wrong with those. You know, she has this secret affair going on with Mr. Frazier. I mean, she's violating her marital vows. She's, you know, there's probably some level of fantasy, you know, that's going on here. So I think based on the conversation she was having with Jerry, at some point, you know, she feels badly and she's looking for someone to sort of buoy her up, right? Support her. Almost, I don't want to say like a victim mentality, but certainly, you know, that kind of, you know, where it's, you know, she's looking for sympathy. She's looking for someone to, you know, provide support for her, right? To make her feel good. I think those kinds of texts with Jerry, you know, if you're commenting on your relationship with Todd, I think it, you know, makes sense, you know, when you're talking to somebody who's, you know, your secret lover. I didn't see anything that, you know, that caused me any kind of, you know, concern.
Did you see any differences in the communication between information that Ms. Mullis was conveying to Mr. Frazier and information that she was conveying to Todd?
Sure. I mean, I think, you know, she's married to Todd. She has children with Todd, right? They have a business together. So some of the texts that she's sending Todd are very playful, loving, you know, discussing things that I think any normal couple would be discussing, things happening on the farm, breakfast, you know, just sort of innocuous kinds of conversations. She did say that she loved him, you know, and, you know, but of course, she's got this secret side of her. So obviously she's not going to tell Todd about that. But it doesn't mean that she doesn't care about Todd. And I mean, that's the sense I got in you know, reading a number of messages. And you can't just read one. You have to, you know, you have to put them in context. You have to read a lot of those, and a lot of those messages to her friends, and evaluate, you know, that, you know, what is that relationship? What is she comfortable telling these different people?
And Your Honor, again, I'm going to object on well beyond the scope of expert testimony. We're just commenting on text messages and things that are well within common sense and reason, and that is not subject as a reliable expert opinion under 5702 and 03, and therefore should be excluded under even 403B.
I mean, I do think we're getting pretty far afield here, Ms. Thompson. You know, if you want to try to tie this back in, that's okay, but I'm not sure what your next question is.
I mean, I'm moving forward, Your Honor. I would just say that there was some testimony from Mr. Firehelm that he personally, in his analysis of the case, believed that there were, and I don't remember his exact words from yesterday, but that basically his own evaluation of the marriage was different than what Mr. Safrick's describing. And one of the ineffective assistance of counsel claims that Mr. Mullis has is that his counsel didn't consult with someone who could have provided context. So this is relevant to Mr. Mullis's ineffective assistance of counsel claim. I agree that, and it's not this witness's intention or our intention to argue that this witness can provide, you know, veracity about these issues, but more context for counsel to have evaluated the issues here and how to present them for Mr. Mullis.
Your Honor, if I may be heard.
You may.
Well, that's certainly not what he authored the report for, to comment on Mr. Firehelm's testimony. He makes direct credibility determinations, and he coins it under a term victimology. There's at least 2 cases which have excluded his analysis, specifically on this point, and reversed for new trials as being inadmissible in the first place, and therefore unreliable. I'm happy to provide those citations now. They're from the Illinois Supreme Court, where they find the entirety of this testimony in line of questioning to be inadmissible, as did the New Jersey court that they relied on too, because it's the equivalent of testimony from a 13th juror to pair it in a theory of a case. That is improper testimony, and we would vehemently object under the expert testimony provisions in 403.
Yeah. And certainly a little different to have the testimony of trial counsel's analysis of the case and attempting to get the testimony in this way through an expert. So again, if you can have him explain how he's qualified as an expert to talk to me about this specific type of testimony in a way that isn't vouching or credibility, which is my domain, I guess we can try to go there. But the way this direction is, or the way this testimony is going, seems to be down that path at the moment. So let's maybe redirect and get back into something that I think is his domain with these investigations, or the way in which he handles them, please.
Understood, Your Honor. And we can take up the issue of that case law because we disagree with what it says, but I understand the court's ruling, and I'll move on to a different topic.
Thank you.
Mr. Safrick, are you familiar with the concept of confirmation bias?
Yes.
And can you tell us in brief terms what that is?
Well, I would say in reference to like a criminal case, the investigators are more likely to search for and recognize what confirms their bias or their theory and ignore or not consider evidence to the contrary.
Did you see evidence of confirmation bias in the investigation into Ms. Mullis's death?
And I'm going to object again, Your Honor. This is psychological evidence, and it's been kept out before because they do not he has no experience as a psychologist. He has no medical experience as a psychiatrist. What is the point of this testimony? Again, under our reading of the case law, courts have kept out the very same thing and found it to be improper, and we would object on those grounds as before. It's the same grounds as before.
Did you wish to respond to this, Ms. Thompson?
Well, the case law that the primary case in Illinois in which a court determined Mr. Safrick's opinions were not relevant actually dealt with his assessment of a crime scene. If the state is referencing People versus King, we can talk about that case. This is not testimony that's offered to provide, the purpose of this testimony is to talk about what this investigation was and why it is that both Mr. Mullis's own attorneys and investigators focused on incorrect information. And that is within Mr. Safrick's province as an experienced FBI investigator, as an experienced law enforcement officer who evaluates these cases. It's to understand why both Mr. Mullis's own attorneys and the authorities would have, focused on particular issues without looking at others. And that's relevant to understanding why it is that Mr. Mullis didn't receive effective assistance of counsel and why it is that this investigation got off track, which again is one of the claims that Mr. Mullis raises in his petition.
And again, Your Honor, if I may, Mr. Safrick's report doesn't speak to that. The ultimate conclusion as set out on page 56 and 57 is meant for him to speak to whether or not this was an accident or a homicide. Specifically, if we look to his conclusion, he said, quote, "I was asked to review this case to determine if a manner of death other than homicide would provide the most logical explanation for Amy's death," close quote. I believe that's at page 57, Your Honor, possibly 58. And so Mr. Safrick's conclusions certainly aren't being relevant to an ineffective assistance of counsel claim. And again, improper testimony invades on the fact finder's function here.
Ms. Thompson, any further response?
Mr. Safrick has not offered an opinion about the cause of death here, although he certainly has one, as the state alluded to. There's nothing about, and his report does discuss the topic of confirmation bias and how that is relevant here. These opinions are just as relevant for what counsel would have taken into account in choosing whether or not to investigate, choosing whether or not to make certain arguments on Mr. Mullis's behalf. That is exactly the purpose of his report. It's information that counsel could have taken into account. That's exactly what we offered it for in our petition, that counsel failed to get this kind of expert opinion, which would have aided in counsel's analysis. There is nothing about Mr. Safrick's report that is inconsistent with presenting it in that way. We have not presented Mr. Safrick's ultimate opinion in this case. That is the province of the court. But these are all the factors that he could have explained to counsel, which would have helped counsel understand what evidence would have been relevant to arguing this case to the jury in Mr. Mullis's case. And I'd say that there's a number of other cases where Mr. Safrick's analysis and opinions have been accepted by courts, and we have a number of those cases we can cite to the court. So the state has pulled out, a couple where courts went the other way, but that's not the Mr. Safrick has testified all over the country, and his opinions have been accepted by courts in numerous states.
To the extent that the court understands Mr. Safrick to be offering an opinion as to the investigation that was conducted into this matter, and not an opinion or as an expert on confirmation bias specifically, the court will allow the testimony and give it whatever weight it's ultimately due. So the objection is overruled. You may proceed, Ms. Thompson.
I'm sorry, what was my last question? And I apologize because I don't recall. I believe the last question may have been.
Did you see evidence of confirmation bias in the investigation into Ms. Mullis's death?
Did you hear that question, Mr. Safrick?
Oh, I didn't. No, I did not.
Let me repeat it. Did you, Mr. Safrick, see evidence of confirmation bias in the Mullis investigation?
Yes.
And can you explain what evidence you saw of that?
Well, I think the first really important piece here relates to the interviews that were done of Tristan and Todd. It's important to understand that the first three interviews of Todd, two of them occurred. The first three occurred on the day, on the 10th. The first three interviews of Tristan, or first two interviews of Tristan, also occurred on the 10th. At no time were those interviews conducted with Todd and Tristan together. They were all conducted independently. In fact, all of the interviews that were conducted, including the ones on the 16th, were conducted independently. So normally in law enforcement, when you have two suspects and that are, suspected in a crime and law enforcement arrests them, the first thing that law enforcement does is separate them. Why? Because they don't want them talking and getting their story together. I mean, this is an investigation 101. And that's exactly what happened here. We have these literally 7 interviews of a 13-year-old boy and Todd explaining to law enforcement on the day. So this isn't occurring weeks later or months later or years later. This is happening contemporaneous with the crime. And what we know from investigations is that the best information from a witness is that contemporaneous information to the event. So the closer to the event, the better, because you don't want that information contaminated. You don't want that person talking to other people or other
vouching, improper testimony. Again, what he's saying is, if I understand it, and certainly the court can make the determination, is that they were telling the truth because their stories were closer in time to the events in question. How is that not a credibility determination, saying they were telling the truth then, but were not later on?
Well, and I think the answer is turning into a narrative. Let's just have a new question, please, Ms. Thompson.
I'll ask another question, Your Honor. Did you see evidence of confirmation bias in the way that authorities relied on the text messages and the messages between witnesses in this case?
Yes, in certain circumstances I did.
And can you explain what evidence of confirmation bias you saw in that respect?
Well, there was a couple of texts that Amy had related to a confrontation that she'd had with her mother-in-law, Peggy Munson. And those texts, if you take the text out of context, it appears that Amy is talking about Todd, that she's going to, if this ever happens again, I'm going to leave, take the kids. And then, so it sounds very damaging by itself, but if you take it within the context of all of the other texts, you realize that she's not talking about Todd. She's talking about her relationship with her mother-in-law and the problems that she had there. And that goes on for a couple of days. And she even has that discussion with Todd. So I think it's really important that you take all of these conversations in context and look at what's going on before and after the conversations.
Just one moment, Your Honor. The text messages that you were just referencing, Mr. Safrick, do you understand that that Ms. Mullis's mother-in-law in this case was Elaine Mullis? Do you recall? Go ahead, Mr. Safrick.
Sorry?
Do you recall, as you sit here today, the name of Mr. Mullis's mother or Ms. Mullis's mother-in-law?
Yeah, sorry, I misspoke. Right.
In general, the testimony that you've provided today, if Mr. Mullis's counsel had consulted with you before Mr. Mullis's trial, is this information that you could have provided to Mr. Mullis's attorney?
Yes.
I don't have any other questions, Your Honor.
Cross-examination.
Yes, Your Honor. Good morning, Mr. Safrick.
Good morning, Counselor.
How long have you had what was your experience like in law enforcement specifically?
In law enforcement?
Yes.
Well, I started in 1977 as a police officer working in patrol. As I said, I promoted into detective, started in property crimes, went to violent crimes. And then in 1983, I applied to the FBI. I got in, and my first office was working in an Indian reservation in Wyoming. I worked there for 3.5 years working all the violent crimes on the reservation. I went and then was transferred to the New York City office. Is this what you're looking for? I just want to...
Mostly, I was just trying to check. I believe it's 30 years or so that you had in law enforcement, right?
Oh, yes, yes.
So is the bulk of your experience testifying in court is actually from an agent perspective, correct? Or an officer perspective, too?
Well, I was a supervisory special agent in the behavioral analysis unit.
Right, but in court cases specifically, is the bulk of your testimonial experience when you've taken the stand has been as an officer or an agent, right?
Yes.
And your background is in law enforcement specifically, fair?
That's very broad. I don't know what you mean by law enforcement.
You have no expertise or specialization in psychology. Fair, you're not a psychologist?
Correct.
Not a psychiatrist?
Correct.
As you confirmed on direct examination, you're not a doctor, right?
That's right.
So you're in the fields of psychology, such as social psychology, you aren't able to speak to the dynamics between people. Fair?
No, I wouldn't say that's true.
Well, you are not a social psychologist who has been certified to testify on that matter specifically, the social psychology of interfamilial relationships, right?
No, I testify about relationship dynamics all the time as an expert witness.
Correct, but your primary expertise, in fact, for the bulk of it, your expertise is in the field of crime scene analysis or law enforcement investigation, right?
Well, yes, I would say that crime scene analysis is the baseline for all of the type of analysis that I do, yes.
And in your report, you detail it as crime scene analysis as being your primary expertise as well, fair?
I don't know that I detail it in my report that way. As I said, crime scene analysis is sort of the bedrock of all of the type of analysis that I do in complex death assessment cases, whether they're homicides or serial murders or equivocal deaths. I have extensive training in that area.
Correct, but on page 3 of your report specifically, you say, quote, 2 published appellate opinions allow my expert testimony in crime scene analysis, right?
Right, I have lots of opinions. I have lots of appellate courts that have upheld my testimony many times. I only put those in there because they were published opinions.
Well, the Illinois Supreme Court also issued a published opinion in People v. King. Are you aware of that case?
I am, yes.
And they found, in that case, would you agree that the appellate court or the Supreme Court of the state of Illinois found your testimony inadmissible in its entirety, correct?
Yes.
And it relied on a similar case by the New Jersey appellate court as well, finding similar testimony on profiling, for instance, or what your testimony was being offered in that case went beyond the bounds of your expertise, correct?
I've never testified about profiling. Profiling is not allowed in the court. Profiling is essentially linking the defendant to the behaviors at the crime scene that would interfere with the purview of the jury and the court and the judge. I've never testified about criminal profiling. And
not even in the case
are you speaking about the Fortin case?
Well, on the matter
You're talking about the New Jersey. You're talking about New Jersey. Is that the Fortin case?
I believe it's State v. Lennon, if that sounds correct.
Yeah, that's the Fortin case, yes.
And similarly, you were found or profiled as an ex-FBI profiler in the case of, I believe, Raymond Lee Jennings, correct? Are you familiar with that case?
Objection.
Yes.
It just, the question, I think, was you were found or profiled as an expert. I didn't understand the term that the counsel was using there, Your Honor.
Did you wish to clarify, counsel? I mean, I guess I heard the witness answer, so apparently the witness wasn't confused.
I mean, I can clarify, Your Honor, but the witness already answered the question.
I guess, Ms. Thompson, if you just want to come back on redirect, you can clarify.
Understood, Your Honor.
Well, you mentioned that you've never done profiling before, and you would agree that it would be inadmissible testimony to do a profile, correct?
Yes.
But similar matters where I guess your testimony in People v. King at the appellate level labeled your testimony profiling of characteristics consistent with crimes. Would you agree with that?
I don't know how they characterize it, but I've never testified about profiling.
So today you're not providing a profile, for instance, of who would have committed this crime, right?
No.
But you are profiling the victim in what you've coined as victimology, right?
Right. You have to understand the history of the victim is when you're looking at a death scene case.
You comment on her behaviors as being manipulative or otherwise, right?
Objection, Your Honor. That was not his testimony today.
Overruled. The witness can answer if he's able.
So part of so you're taking things out of context here. I said that when you look at Amy's conversations with various people, she presents a different side of herself to whomever she's talking to. That is a relatively normal thing most people do, depending on the relationship that a person has with the person they're talking to.
But you would agree, thank you, Mr. Stafford, but my question really was, you refer to her at times as being described as manipulative or otherwise, fair, in your report?
Yes, I did.
So those findings comment on her characteristics as a victim, right?
Well, I've characterized a lot of things about her.
Right, her personal traits, fair?
Right, and this was also referred to by other witnesses who described her the same way.
So I guess Mr. Safrick, you're just going, is it fair to say that you drew all of your inferences from the existing record evidence established or collected by law enforcement on this side of things, or presented at trial? Is that about right?
Well, I didn't do any independent investigation. I didn't, go to the scene and conduct an investigation. So as I always do, I have to rely on the reports and the investigation conducted by law enforcement and others associated with the case, like the medical examiners and toxicologists and such.
But on direct examination, you testified that there was no scene in this case. Is that right?
There was no staged scene.
Well, you would agree that Amy Mullis was found on her hands and knees on your review, right?
She was found with her hands tucked under her, yes, lying on the floor in the shed.
And she was found impaled by a corn rake.
Yes.
And you would agree that based on the evidence you reviewed at least, Mr. Mullis sent his son to find the pet carrier check on it, right?
Correct.
And ultimately sent him in to find his mother, true?
I don't think he sent him to find her. He sent him to get the pet carrier.
And in doing so, find his mother, right? Or found
Yes.
his mother.
He did.
And then Mr. Mullis grabbed the corn rake and pulled it out of Miss Mullis's back, right?
Yes.
And in doing so, touched the weapon, in this case, or what would be called a poor weapon, I believe as you characterized it, right?
Yes.
And so there wouldn't be any DNA evidence specifically that you'd be able to pull from the handle of the rake, right?
Why wouldn't you be able to pull DNA evidence?
Well, let's say fingerprints. Mr. Mullis's fingerprints would be on the rake then, right?
They could be.
So in your experience of 30 years in law enforcement, you would agree pulling latent prints might be difficult, right?
Pulling latent prints depends on the surface you're pulling them from. So if you have an old, worn, dirty corn rake handle made out of wood, probably be difficult to pull latent prints.
And so when Mr. Mullis pulled the corn rake out of Amy Mullis's back, he discarded it next to her at some point, right?
Yes.
And you would agree that based on the record evidence, Mr. Mullis admitted to putting the rake in that shed, correct?
Well, yes, his recollection was that, 2 weeks prior, he set it against, but he hadn't seen it since. Set it against the wall, but hadn't seen it since.
But he was the last person, based upon your review of the records, who knew or saw that corn rake with any certainty, right?
Yes.
And it was Mr. Mullis who sent Amy Mullis to get that pet carrier, correct?
Yes.
So he sent her to a specific location, right?
Yes.
For a specific purpose, right? Where nobody else would be, true?
Well, he didn't know that his other children wouldn't be out there.
Well, you're speculating on that front, fair? You don't know one way or the other. You have never interviewed those kids, and you have no testimonial statements one way or the other as to whether he thought they'd be in there, right?
Objection, Your Honor.
No, but look, I'm looking
sorry,
at this.
Mr. Safrick, there was an objection.
Oh, I'm
It's,
sorry.
I'll withdraw the objection, Your Honor.
Oh, now the objection's withdrawn. You may continue your answer.
So I'm looking at all of this is what is reasonable, what is likely by reasonable inference. So the information is that Todd and Tristan were in the hog barn with Amy for an hour maybe. So there's no way he would actually know where his other 2 children were.
Well, you know he left them inside the house, right?
Yeah, but they're 8 and 10, they're kids. So
well, in the middle,
you'd have to be certain
but
they weren't going to be outside.
But you can't be certain that he didn't know they were going to remain inside, right? Because you don't have any independent information and you have conducted no investigation yourself, right?
Correct.
You speak at length about the manners of death to be investigated, right? The 5 different manners of death that are recognized, true?
Well, just in terms of an equivocal death evaluation, yes.
But ultimately, you agree that in your conclusions, you were asked to provide an opinion on whether the manner of death in this case was homicide or that there was a more logical explanation for Amy's death, right?
Right. When I got the case, I didn't know anything about the case in terms of, I knew how she died, but what the manner of death was, I didn't know. That was my point. It was to conduct an equivocal death evaluation that basically determined that it was either going to be, that the 2 most consistent manners would either be homicide or accident.
So your conclusion was the 2 most consistent manners of death, in your opinion, would be homicide or accident?
Right, because there was nothing there that indicated this was a natural death, and there was nothing, in my experience, in terms of having seen well over 4,000 homicide cases and death cases, that this was a suicide. So, you know, by reasonable inference, you're left with either accident or homicide.
You would agree that Google searches in the history as introduced at trial, though, about, quote, what happens to cheaters in history, in, quote, killing unfaithful women, would point to potential motive or any purpose, right, based upon your understanding of planning?
Well, see, Counselor, I think you're taking that out of context. That's not very good of you to do that. It's completely out of context. Those searches appeared to be related to schoolwork.
Your testimony today is that, quote, killing unfaithful women was a school assignment?
You're taking it out of context, I think. That's my opinion. There is information that suggests that these were searches done by the kids.
And I might have missed it in your report. Did you at any point reference those Google searches?
No, I did not.
So nothing that would have potentially cut against the point. You only found one factor that weighed in favor of finding it was a homicide, right?
Objection, Your Honor.
Yes, I did.
The basis of your objection, Ms. Thompson?
That's a compound question, Your Honor, but the witness has answered, so I'll withdraw the objection.
The objection's overruled. The answer will remain in the record.
And that was that most women are murdered by people they know. That's right?
Yes.
But you didn't weigh any other motive evidence, did you?
Counselor, I reviewed all this information in detail. I was open to the possibility that this was a homicide and that the counsel that contacted me was, you know, incorrect. And that was my job, to figure out what, based on the information and my review of all the information, what was the most likely inconsistent manner of death. That was my job. And I considered it a homicide as well.
Well, correct me if I'm wrong, but in your report you don't mention Tristan Mullis's trial testimony, do you?
I don't know. I listed everything that I used, you know, that I received and reviewed. I have to say that I wrote this report in the end of 2022, beginning of 2023, so it is several years old for me at this point. But I have listed everything that I reviewed.
Well, I'll ask you this question. Do you recall anywhere in your report that you testified to your conclusions at length on direct examination, for instance, that report, do you mention Tristan Mullis's testimony that Todd Mullis's father was out of his sight for an indeterminate amount of time?
If you can reference to me, I believe you're referencing an interview with Tristan that occurred well over a year after the incident.
I'm not, Mr. Safrick. Did you review the trial transcripts in this case?
If I have them listed, I did.
But you don't make reference or note them in your report, do you?
Well, I listed in my report what I reviewed.
So I guess I'll phrase it in the hypothetical then, Mr. Safrick. In your opinion, if Tristan Mullis, under oath, swore that his father left the hog barn and left his site for an indeterminate amount of time at trial, would that change your testimony?
No.
Why?
Because, as I said before, the initial interviews are, in my experience, the most accurate, and when they're contemporaneous with the event, they were unfiltered, unbiased, unimpeded. There was nobody to influence him. By the time trial has come around, what he heard and who has talked to him and who has influenced him, I don't know. But those kinds of that kind of testimony is problematic for me. I relied on the contemporaneous interviews done by law enforcement on that day, multiple interviews with both Tristan and Todd, independent, where their stories were exactly the same.
Well, Mr. Safrick, I'm going to ask a follow-up question on this one. Does it change the fact that at each time Tristan Mullis took an oath to tell the truth and testify in a deposition or a court proceeding like you did today, does that weigh in favor of finding that to be a potential protective factor, that maybe this was a homicide?
Again, I reviewed in my complete review that everything suggests that this was not a staged case and that this was not a homicide.
Correct. But my question was, does Tristan Mullis's sworn testimony that Todd Mullis left his site change the fact that those are his under oath statements, and the statements you reference were not under oath?
Objection.
I understand.
Objection, Your Honor. That misstates the testimony and the facts in this case.
overruled, the witness can answer.
Yes, so I understand what you're asking. I understand that those statements were under oath, but I would consider them. But I would say that in the context of everything that I reviewed, the contemporaneous statements made by a 13-year-old boy were accurate, and he repeated those statements. And not only that it's consistent. His statements and Todd's statements are consistent with what would be expected if you found your wife, unresponsive in a shed. Those activities of lifting her head and wiping her face, all of those things are consistent with somebody rendering aid, yelling at your son to get the truck. Those are all consistent, and those statements were consistent. So I would value those statements in the context of everything that I reviewed more than I would the statements under oath.
So the sworn testimony is less than the unsworn statements, yes? Did I just understand that correctly? I'm only confirming as a yes or no.
Sure. Yes. Yes. That's how I would view that. Yes.
Do you have your report in front of you, Mr. Safrick?
I do.
Can I refer you to page 6 if possible?
Certainly.
Let me know when you're there, please.
I will. Okay.
In the first paragraph at the top of page 6, in the last sentence, I believe, I'll read aloud and let me know if I read it correctly. Quote, "In this case, I yielded the attempt to reconstruct an exact sequence of events. Such an attempt is impractical due to the innumerable possible interactions between Amy, the environment, and others." Did I read that correctly?
Yes.
In your opinion, then, an accident reconstruction wasn't feasible here. Is that fair to say?
No, what I'm saying is that oftentimes when I'm questioned at trial, counsel will ask me, isn't it possible that this could have occurred? And generally what I would say is that when you're dealing with what's possible, literally thousands of things are possible. It's impossible to know the exact sequence to the second of what is actually occurring. So rather than dealing with possibilities, which is nearly impossible, my job is to look at what is likely by reasonable inference from the evidence, the physical evidence, behavioral evidence, forensic evidence. I can't deal with what's possible. The possibilities are endless.
Well, I appreciate that,
That's
Mr.
what I'm
Safrick.
saying there.
I appreciate that, Mr. Safrick, but on
Sure.
page 6, you are speaking about reconstructing the exact sequence of events, correct?
Right.
And so you said such an attempt to, quote, reconstruct an exact sequence of events, I believe those are your words, is impractical, right?
Correct.
So in your opinion, it would be impractical to be able to speak to any certainty about the exact sequence of events, right?
Yes, you can't speak to certainty about the exact sequence, and I can't know the exact sequence of literally any crime that I've looked at, but I can draw reasonable inferences based on the evidence.
So just to clarify, I guess, as we work towards the end here,
Sure.
we can agree that Todd Mullis asked Amy Mullis to go get the pet carrier, right?
Yes,
So he sent her to a location, right?
he did.
And we can agree that at least Tristan Mullis's sworn testimony was that his father left his site for an immeasurable amount of time or an unknown amount of time, right?
Objection, Your Honor. That misstates the testimony.
Well,
I don't know what the sworn testimony was.
the answer will remain in the record.
But you reference and cite in your report, which you have in front of you right now, Mr. Safrick, that you reviewed the trial transcripts, right?
Like, I don't know, I have multiple pages of things I reviewed. I don't recall if I did, or if it's listed here, I did. I just, I just have multiple pages, and it's a couple years ago I wrote this, so.
And in this period of time, you have never once evaluated reports or information provided by a Valentina Nye, for instance, right?
I'm sorry, by who?
That, I think, answers my question. You haven't referred to reports or reviewed reports from one Valentina Nye, right?
No, I have not. Dr. Nye? No.
Correct. Dr. Nye would be a way to
Correct.
refer to her.
That is correct. I have not reviewed any reports of hers.
And your conclusions around the scene and the distances between buildings aren't based on your research or your findings specifically, right?
Right, I relied on other experts who conducted those measurements.
And would you agree that there is a difference or a distinction between one being dead or deceased and one being pronounced dead?
I'm not clear on your question.
Sure.
Someone's dead or they're pronounced dead?
So Amy Mullis was pronounced dead at the hospital, correct?
She was.
But she was found unresponsive in the shed on your review, correct?
Yes.
And there were not signs of life accordingly at that point in time. Is that a fair description of the evidence or the record?
Objection, Your Honor. This is calling for a medical opinion from this witness, which he stated he's not providing.
But the witness can certainly, I guess, testify as to his understanding based on his review of the records. I won't interpret his testimony as providing any medical opinion. With that understanding, Mr. Safrick, you may answer the question if you remember it at this point.
I do. Thank you, Your Honor. Yes, I don't believe there was there's anything that indicated that she was dead in the shed. She was transported. They were doing CPR on her at the roadside. And I believe, if my recollection serves me correctly, that the doctors in the hospital worked on her for over an hour. So at some point she was pronounced deceased, but there's no evidence that she was deceased when Todd found her in the shed.
Did you find any?
She was unresponsive, but no indication she had already passed.
Did she ever come to or become responsive again based on your review of the evidence?
Counselor, that would be a question for the emergency room doctors who worked on her. I don't know.
Although you just testified to what they found or how long they worked on him, right?
I believe that my recollection is they worked on her for about an hour before they pronounced her.
But you can
So
come to
my sense is that they believed that she was alive. I mean, I have a lot of experience with individuals who are either declared deceased at the scene because it's apparently obvious they're deceased, or as soon as they get to the hospital, they're declared deceased. That's not what occurred here. So
she wasn't declared deceased at the hospital?
Not immediately. I've had hundreds and hundreds of cases where offenders or where victims are declared deceased as soon as they arrive at the emergency room. But that was not the case here. So I don't know. There's nothing that says that she was deceased, and people believed because they were working on her that she was still alive.
Sure. Mr. Safrick, we were provided a list of your prior testimony in the last 4 years. I believe that lists, is it 2 trials that you testified in? Or 1 trial?
I don't have that list in front of me, but whatever, it should be accurate, yes.
How many trials do you believe you've testified in the last 4 years or so?
Trials, probably those 2.
And
there's 2 on there.
You also list depositions, I believe, for a grand total of 4 items or 5 items or so. Does that sound about right?
Yes. If I provided that, that's accurate, yes.
And it isn't in criminal cases specifically, right?
Well, they're civil cases, but they're all related to criminal, typically homicides. So I have to evaluate all of those homicide scenes.
Sure. And how much were you paid for this case?
Well, not enough. But I did a lot of the work pro bono after. I got paid initially, but I've done a lot of work pro bono, and I'm not, just because, they don't really have the money. And I think it's worthwhile to provide my insight in this case.
Thank you, but that didn't actually answer my question. How much were you paid on this case?
I think $10,000.
Okay. And how much pro bono work have you done?
I do a lot of pro bono work for various organizations. All my work for the VDOC Society is pro bono. I do other cases pro bono. So.
Right, but I'm asking specifically about this case, Mr. Safrick.
This case. Right, and a lot of my time, probably 25 to 30 hours has been pro bono.
Is your hourly rate $500 an hour for a 4-hour minimum?
That's my testimony for depositions, but my hourly rate is $400 for analysis and casework.
And how many hours have you done of work on this case?
I don't know offhand.
Could you ballpark it like you did for the 25 to 30 hours of pro bono work?
60 to 70 hours of work. It's been over, I was retained in July of 2022. So it's been, 3 years?
So 60 to 70 hours of work total or inclusive of your quote unquote pro bono hours?
That's probably total.
I don't have anything further. Thank you.
Any redirect?
A few questions, Your Honor. Mr. Safrick, I'm going to show you what's been marked as Exhibit 281.
Thank God he's done. God, he is snappy, Donnie. He wears me out. Like, he makes me a nervous wreck. I'm like, God. He's so hateful. And, I mean, I get it. He's doing his job, whatever, but I just can't stand I'm talking about this case, Mr. Safrick. That's cool about all the other things, but no, I'm talking about this one. I get it. I understand what he's doing, but still, no, I don't like him. He could be a contestant on RuPaul. He's so full of himself. Hey. I don't know about him. Let me see how much longer they have with this guy. I'd say they're probably about done with him. We'll get through this witness and then we'll call it.
While this is being pulled up, this is a multi-page document, and I'm going to have my colleague scroll through Exhibit 281, and I'm going to ask you if this looks like a true and accurate copy of your CV and your report in this case.
I'll object, Your Honor. This isn't in evidence, and certainly it includes hearsay statements and testimony, and we would, have that evidentiary fight later on, but we've been having it for quite some time, so as the court knows, we would reiterate our same objections here. Also, this report's unsigned, out of compliance with the rules of civil procedure, and therefore not properly applied to. But we would raise our standard objection. Thank you.
All right, thank you. I guess, counsel, were there additional arguments that you wish to address?
Did you see that? We would raise our standard objection. Thank you. And he did this real, like, poop-eating grin. Watch him. He gives me hives.
Evidentiary fight later on, but we've been having it for quite some time, so as the court knows, we would reiterate our same objections here. Also, this report's unsigned, out of compliance with the rules of civil procedure, and therefore not properly applied to. But we would raise our standard objection. Thank you.
All right, thank you. I guess, counsel, were there additional arguments that you wish to address at a later time with regard to this exhibit, or?
I'm just showing him a CV, Your Honor. That was my intention right now.
Okay. Well, go ahead with that for now.
Yes, this is my CV. When I update my CV, I change the date at the bottom of the pages, so it shows January of 2025. I think I had an article published, and so I updated the CV, but that's accurate.
All right, and Exhibit 281 is a true and accurate copy of your CV and your report in this case?
Well, all I can see is the CV at the moment. But yeah, that's my CV, yes.
Let me know when you've had a chance to determine whether this is a true and accurate copy of your report.
Okay. Yes. I was looking for the date on it. Appears to be yes.
Your Honor, we can.
It's 57 pages. If it's 57 pages, then yes.
All right, and Your Honor, we can take up any other issues with this document at a later time.
All right, we'll do that.
You can take the document down. You were asked some questions about medical issues in this case. Did you review reports from a forensic pathologist and a biomechanical engineer related to the Mullis case, Mr. Safrick?
I did.
And do you defer to the expert opinions of those experts in their respective fields?
I do.
And do you, when you indicate that you are not able to determine sort of when you are not able to determine exactly how events might have transpired here, do you intend to offer an opinion about whether a biomechanical engineer could offer opinions about that topic?
No, I don't.
I mean, are you disputing any of the opinions of pathology and biomechanical experts in this case?
No, I'm not.
You were asked some questions about the RAKE and some of the things that occurred after Ms. Mullis was found in this case. Was Mr. Mullis removing the RAKE from Ms. Mullis, was that an attempt, is that behavior that's consistent with staging a scene?
No.
Why not?
Again, the purpose of staging is to create a scene that law enforcement can attend, the investigators can attend, and then see the scene and make their assessments on the adulterated, changed scene. Because again, you're trying to create a new motive for the crime, and then, that's what you want. That's what you want law enforcement to see. So you don't create it and then destroy it. And everything that I saw is consistent with him rendering aid. It's consistent in their statements as well, with him rendering aid.
If there is testimony in this case that Mr. Mullis's daughter, who was a minor, saw the corn rake in the shed near the time that Ms. Mullis suffered her injuries, would that change your opinion that Todd Mullis was the only person to reference seeing the rake in that area?
Objection leading.
Overruled.
Yes, I knew that the kids played in the shed, and Tristan suggested at one point that maybe they had moved the rake, but I don't think anybody knew where the rake was. It was never identified in a particular location, except I think Todd said a couple weeks prior, he put it against the shed door.
And are Todd's statements about where he left the rake, are those consistent with someone staging the scene, as you testified about?
Objection, vouching and improper testimony, 403 prejudice.
Sustained.
I didn't ask you your opinion about how you would evaluate the cause of Ms. Mullis's death, but the state did. So I'll ask you, did you reach a conclusion about what the likely cause of Ms. Mullis's death was?
Objection, improper opinion testimony. He can't come to a pathological diagnosis, Your Honor.
They opened the door to this, Your Honor.
Did you want to respond to that, Mr.
Sure.
Rudin?
We didn't have a report. We didn't ask for his report to provide us an ultimate testimonial determination. Ultimately, the question was, isn't the basis of your report in the ultimate conclusion for you to decide whether or not this was a homicide or an accident? That's what's cited at 56 and 57. When he was coming to a determination, he said he couldn't speak to a manner of death specifically because he's not to undermine the pathological opinions or the medical opinions here. Simply put, that's the basis of that testimony was to object on the basis of that he is not an expert who can provide that and render an opinion.
Yeah, I guess, Ms. Thompson, that's how I understood the witness's answer as well. If you understood or believe something differently, you may respond, but otherwise the objection sustained.
Well, just to make clear my point, Your Honor, the state asked him a number of questions about why he did not determine this was a homicide. We don't intend to offer him as a medical expert. He's not a medical expert. But given that they inquired about those conclusions, it's our position we should be able to inquire about his conclusions as well. But I understand the court's ruling, and I'll abide by it.
Thank you.
One moment, Your Honor. Two more questions, Your Honor. One is, Mr. Safrick, you were asked some questions about whether you're testifying as a profiler in this case. Are any of your opinions in Mr. Mullis's case based on your experience in profiling possible criminal defendants? Your Honor, I don't know if the witness was able to hear me. It might have been because my mic was off. I apologize. Let me just read. Mr. Safrick, I assume you could not hear my question. I apologize. I think my mic was off. So let me restate.
No, I didn't hear it.
Apologies. Let me restate that question. You were asked some questions on cross about whether the opinions you were providing in this case were based on your experience as a profiler. And my question for you is, are any of the opinions that you're offering about the Mullis investigation opinions you're offering in the context of being able to profile potential criminal defendants?
No.
I don't need a question, Your Honor.
Any recross?
No needed, Your Honor.
All right, thank you, Mr. Safrick. It appears that your testimony is complete. I'll go ahead and end the Zoom at this time.
Thank you, Your Honor.
For those of us here in the courtroom, this is probably a good point to take our morning recess. Let's break for about 15 minutes and plan on picking up at 11:20. Court is in recess until then.
All right, y'all. I cannot with him. He was that kid in law school, right, Donnie? Probably the teacher's pet, the front row. Yeah. Oof. Ay, ay, ay. I'm done for today. I'm done for today. So we will resume here tomorrow. And yeah, that's what we'll do. I'll save it for right there. And we'll resume right here tomorrow. All right. He probably argued with the teacher. Yeah, probably. Probably. I mean, by teacher's pet, I don't know. I don't know. For me, I guess it could go either way. I guess it could go either way. I just know I don't like him or his haircut at all. As far as whether or not I think the judge will give him a new trial, I still don't know. I mean, I know some of you guys, Michelle and Donnie, feel like she won't. I don't know. I kind of feel like she might. But then again, I'm wrong an awful lot of the time, so we will see. Hey, Kayleen, good to see you. All right, you guys, I'm going to scooch on out of here and go spend some time with the family. And yeah, I will see you guys back tomorrow morning, probably about the same time, maybe a little earlier. Just depends on her schoolwork stuff. So, but thanks for joining me all day today. I appreciate it. You guys are the best. You're simply the best. Better than all the rest. Oh, are you going to go see your mom, Michelle? Tell her hi from the Crime Cafe. All righty. All right. You guys have a good night too. Kel, get you some rest, girlfriend. Well, shoot. It's like, what, 1:09 for you? You still got a bit to go today, huh? All right. I will catch you all tomorrow. Have a great night. Make sure to hit the thumbs up before you leave. Subscribe if you're new, and hashtag replay in the comments down below if you're watching this on the replay later. Alrighty. I'll see you guys tomorrow. Bye.